Court rise.
Hearing in the appeal, Attorney General of Trinidad and Tobago against Ayers-Caesar.
Yes, Mr. Stevens.
My Lords, my Lady, I appear on behalf of the appellant with Daniel Goldblatt, and for the respondent, Mr. Peter Knox of Queen's Counsel appears with Mr. Robert Strang and Mr. Philip Judd. My Lords and my Lady will be familiar with the background, which is relatively straightforward and appears sufficiently, I think, in the statement of facts and issues. It is somewhat more fully set out in the appellant's case at paragraphs 3 to 13, and I shan't repeat any of that. Suffice it, therefore, by way of brief introduction, to say that the appeal is from the grant of leave to seek judicial review of the second only of two alleged decisions of the President, described in the application as his, I quote, continued refusal to set aside the appellant's resignation and to reinstate her as a judge. The resignation having been effected by letter handed to the President on the 27th of April 2017, and the alleged refusal on the part of the President to set aside the resignation occurring only after receipt of a long letter from the respondent dated the 19th of May 2019, some 3 weeks later, in which, in summary, she complained that she was unlawfully forced to resign by the Judicial and Legal Services Commission, and she asked the President, therefore, to acknowledge that her removal from office, as she described it, was unlawful and unconstitutional and of no legal effect.
Yes.
Finally,
whether the President had some sort of independent review function.
Indeed.
Yes. Can I just say this, by the way, we've been talking about the case. We're slightly concerned that it seems to have sort of outgrown, when you're talking about quite long presentations. I mean, first of all, this is a leave application.
I entirely accept that.
So we wouldn't normally expect to be deciding great constitutional issues. Secondly, I mean, looking at Mr. Knox's final page where he summarizes his points, taking them in reverse order, I mean, one point he makes sort of is that the President is a proper party to these proceedings anyway, sort of nominally, because anything that's done is done in his name or her name. Is it her now or him? I'm not sure it's her.
I think her at the moment.
Her name, yes, anyway. But, so he or she should nominally be a party. Now, that's a fairly straightforward point.
It is.
And, you know, arguably it doesn't really make much difference whether he or she isn't, because he or she would be bound anyway while the court decides. So that's point one. The next point, which is more contentious, is the one I mentioned, which is whether he had any sort of independent review function. And this is the issue on which the Court of Appeal divided, and the Court of Appeal, the majority thought that there was an independent function. And so you would have to persuade us that it's not even arguable that the majority should have done that. And then I suppose there is a sort of third point, is, well, is it all moot anyway, given that the matter is before the court? Because it's not entirely clear, assume the President did have some review function, how he would have exercised it, other than by referring it to the court or something like that. And in any event, once the matter is before the court, arguably, well, there's not much point in it going back to the President. Now, that may raise issues about whether there would be some damages or something. But, I mean, those seem to us to be the sort of parameters of what we're talking about. And given that this is a permission application, it's, you know, it's not a very complicated point.
No.
So I'm hoping that we may not need all the time that you've set yourselves.
The message is received and clearly understood, my Lord, and it's not my intention to take you through this I hope it's not anyway.
Yes, perhaps I should also say, I know Mr. Knox has brought in all sorts of prerogative points,
Yes.
which we're quite familiar with in this court.
Yes.
But I very much doubt for myself that
Yes.
this is going to turn on that. I mean, it seems
Well,
to turn on the Constitution.
My Lord, yes. I mean, very briefly, but not wanting to get into my submissions at this stage, our submission is, when this goes both to the point you raised that this is an application from the grant of leave and also to his public interest point, this is a straightforward point of law. The Court of Appeal, and with respect, Mr. Knox in his new argument, were plainly wrong. It is unarguable that the President has the alleged power. And in those circumstances, the point can and should be decided at this stage, because if that's right, there's no warrant for a full hearing.
But do you quarrel with the view that, at the sort of bottom level, the President is a proper party, in a sense, nominally?
Well, I quarrel with it in the sense that he is not a necessary and therefore not a proper party, because...
But it doesn't really make much difference.
No, it doesn't matter which way you put it, but...
So let's get on to the issue, which you've got to satisfy us that it's unarguable that he
My Lord, I do.
had any right.
Just briefly to explain how I'm proposing to do that, I'm going to deal in a moment, after a few more introductory remarks about the Court of Appeal's judgment, I'm going to deal first of all with the decision of the Court of Appeal. Then I am going to deal with the other 2 points that raised their head below, and they are in a sense interlinked, one being whether he, the President, is a proper party or a necessary party, and the other being the public interest point. And then I am going to deal with the new argument.
Can you just help me on a point which is sort of interesting us? What is the present position in relation to the complainant? Is she, in fact, simply suspended while all this is going on?
Well, I'm not sure suspended would be the
Or
right word. So far as the state is concerned, she has resigned.
Yes. So she's not sitting?
She's not, no, she's not sitting.
And what's happened to all her cases? Are they all waiting?
As I understand it, but I will, I hope, be corrected if I'm wrong, arrangements were made for those to be dealt with by several different means.
Good. Okay.
At one point, there was a suggestion that she might...
Behind nodding, so maybe...
No, I'm told that's correct. At one point, there was a suggestion that she might herself return to the magistracy and deal with them.
Yeah.
But that was overtaken and they were reallocated to other magistrates.
Anyway, we're not concerned.
You're not concerned with any of that, no, my lord?
So, I mean, the practical position is she's not serving either as a High Court judge or as a magistrate.
No, she's definitely not.
So she is in a form of suspension.
Well, she's in a form of suspension, but I for obvious reasons, hesitated.
The concept of being suspended, a suspended High Court judge.
My
Yes.
lord, yes. So, my lord, I got to the point where I was just literally going to say by the last word of introduction that the President's response to that letter from her was to say that it would be inappropriate and out with his powers, and that remains our position to do anything. Now, my lord, upholding the judge, the Court of Appeal by a majority found that the decision on the part of the President, as you know, was potentially amenable to judicial review. The essential question, as your Lordship has put to me, I therefore accept on this appeal, is whether the majority was right to find that there was an arguable case justifying the grant of leave. I respectfully submit that they were wrong for essentially 2 reasons. First, the President had no duty or power to consider the appellant's complaints with a view to setting aside her resignation, or indeed any power to set it aside. And secondly, that being so, he made no decision by refusing to do so, which is amenable to judicial review. As to the judgments of the Court of Appeal, which I'm not going to take you to, I'm just literally going to summarise the headline points, if I may. The majority held that Section 142 of the Constitution, which governs resignations from offices established under the Constitution and which I rely on and I'll come to, including that of a High Court judge, applied only to valid resignations and did not therefore preclude consideration of the resignation by the President. and accordingly, it was arguable that the President had the power to, and they put it in this way, reconsider his decision, or at any rate, Justice of Appeal Mendonca said to reconsider his decision to receive the resignation, or, as it was put by Justice of Appeal Jamadar, a power or duty meaningfully to consider the substance of the respondent's allegations. And finally, in relation to their judgment, Justice of Appeal Mendonca went as far as to say that it was arguable that the President had a power to determine the circumstances in which the resignation was tendered. Now, my Lords, all I would do over and above that is invite your attention in due course, I know you've read it already, to paragraphs 40 and 41 of our case, which I'm not going to repeat, where we set out the steps in the reasoning of the majority. Crucial, however, to the majority's reasoning was one decision, namely the decision in our in Hertfordshire County Council, ex parte Chung and ex parte Poe, which with respect we say they were plainly wrong to rely on. And that in our submission was the mainstay of their reasoning. And whilst the appellant seeks to uphold the majority, it's not entirely clear with respect to what extent she does so by reference to ex parte Chung. Certainly Mr. Knox hasn't made anything of it in his case. The respondent does suggest that according to Justice of Appeal Jamadar, there was a power of reconsideration which was to be implied into the Constitution. As to that, to the extent that he did so find, and it's not entirely clear with respect that he did find that in terms, I submit with respect that it's hard to discern any reasoning at all to support that implication. Rather, what he clearly appears to have done is reason to the conclusion essentially because, as the Court of Appeal held, both judges, Section 142 only applied to a valid resignation. At any rate, I respectfully submit that there's no way in which such a power can be implied into the Constitution. And then, before turning to the provisions, it is now said, by way of a new argument, that the President has the power, and it's put slightly differently, to consider a request to treat a letter of resignation as not having been given or as withdrawn. And that, it is said, derives from the common law rule that the resignation of an office was not effective until accepted by the Crown, that being an instance of the prerogative of appointment. Now, my Lords, with that summary, can I, before developing my submissions, which do turn essentially on the wording of the Constitution, just take you briefly to the relevant provisions so that you've got those. First, the 1976 Constitution. I'm going to work backwards because it's that Constitution which is current and was current at the time. That is in the Authorities Bundle, tab 2, page 718. I say it is, not all of it, but the relevant sections for my purposes are. So, section 104 is to be found at page 733 of the bundle. The judges, other than the Chief Justice, shall be appointed by the President acting in accordance with the service of the JLSC. Then section 142, subsection 1, at page 738. Subject to the provisions of this Constitution, any person who is appointed or elected to or otherwise selected for any office established under this Constitution, including the office of Prime Minister or other Minister or Parliamentary Secretary, and that does include a judge because it is established under the Constitution, the office of judge, may resign from that office by writing under his hand, addressed to the person or authority by whom he was appointed, elected or selected. And then subsection 2, the resignation of any person from any such office shall take effect when the writing signifying the resignation is received by the person or authority to whom it is addressed, or by any person authorized by that person or authority to receive it. And finally, for completeness, 1431, where any person has vacated any office as established by this Constitution, including the office of Prime Minister, etc., he may, if qualified, again be appointed, elected or otherwise selected to hold that office in accordance with the provisions of this Constitution. And my Lords, turning straight away to the predecessor to the 1976 Constitution, namely...
We don't have section 137, which is removal from office.
No, you don't. That lays down the procedure for removal, which is not a procedure that was engaged. And for that reason, you haven't got it. The point being that whilst the respondent may say, well, if you wanted to remove me, that's the procedure you should have followed, the state says that she voluntarily resigned.
Yeah, I mean, there's no dispute that had they wanted to proceed down that route, there was a well-established procedure for doing it.
For removal, yes, and it is section 137.
Which involves protections and so on.
Undoubtedly, yes, undoubtedly. But that, my Lord, is only background in the context of this. Then 1962 Constitution is at tab 11, page 913, and section 75 you will find at page 938, and it is the section that corresponds to section 104. So section 75(1), puisne judges shall be appointed by the Governor-General acting in accordance with the advice of the Judicial and Legal Services Commission. And then section 103, 1 and 2, I'm not going to read them, they're at page 947, but they correspond with section 142 and 142.1 and 142 of the 1976 Constitution, as does section 104.1 with section 143.1 of the 1976 Constitution. My Lords, additionally, and hopefully Mr. Knox in his supplemental note, at tab 2 of that document, which is in a slim, 1 centimetre thick, comb-bound volume headed Respondent Supplemental Note, at tab 2, I'm afraid that there's no bundle pagination, so could I just ask you to look at internal page number 34, which you'll find in the top left-hand corner.
Very sorry, I'm just
Sorry, my lord.
applying this.
Oh.
What is the bundle that you're referring to?
Respondent Supplemental Note, my lord.
I've got respondent supplemental bundle.
Well,
That's different. There's
that's
two.
different.
There's
Yes,
one which looks like a bundle, which is the note, and one which looks like a note.
That's right.
which is a bundle.
yes. That's the thicker of the two.
I'm very sorry, and it's
we
almost
got a
in my
spare,
report,
mate?
but I don't have.
I'm sure we have,
copy of-
yes, my lord. Yes, indeed.
Everyone else.
Thank you very much.
Not at all. So, my lord, tab 2, please. And as I said, there's no pagination at the bottom, so could you turn to internal page number 34, which you'll find in the top left-hand corner.
And the point of going to this is what?
The reason for referring to this and to the 1962 Constitution at this stage is simply because it's convenient to do so. Their relevance, if any, is to the new argument.
I see.
I just didn't want to be going back to the bundle of authorities later.
So,
Do you have an electronic page? I've got it in electronic form.
Oh, well, my lord, I didn't know you did, and I therefore don't. I'm very sorry.
Your internal 34.
Internal 34. It's section 65, which is two-thirds of the way down that page, under Part 5 of the Supreme Court.
Yes.
Section 65(4) provides for the appointment by the governor by instrument under the public seal, but again on the recommendation of the Judicial and Legal Services Commission. And finally, so far as this review is concerned, could you turn now, I'm sorry, my lord, but another internal page reference, 49. Now, that's less easy to find because there's no section number on the page, but page 49, and at the top, the second paragraph down in brackets is 5. Now, in fact, that is section 90, which starts on page 47, subsection 5, 90 being headed interpretation. But actually, this is a bit more than interpretation, I think one might fairly say. Subsection 5, save as otherwise provided in Part 2 of this Constitution, any person who is appointed to or to act in any office established by this Constitution may resign from that office by writing under his hand addressed to the person by whom he was appointed, and the resignation of any person from any such office, including any seat in the chamber of the legislature, by writing under his hand addressed in accordance with this Constitution to any other person, shall take effect when the writing signifying the resignation is received by that other person. So essentially exactly the same provisions in all three of those constitutions. Now, my lords, can I come there? I'm sorry,
Just so you know, the electronic pagination is 4 pages ahead of the internal pagination.
Well, I'm going to make a note of that and hope.
If we go back,
hope.
it certainly helped me to have the electronic.
I completely understand. My lord, I hope that I may not return to this document, but if I do, I'll try and remember that. Can I therefore come to that which I'm going to deal with first, which is the decision of the Court of Appeal with regard to the alleged power? I've already indicated broadly what our position is, but just to develop that really quite shortly. And I am at paragraph 34 of my written case. I'm going to make these submissions by reference to the written case. First, I'm sorry. It's page 665 in the electronic bundle, my lord.
Right.
So first, the office of the President is a creation of the Constitution. That's section 22. And his powers are, I submit, circumscribed is perhaps the better word, by the Constitution. And in appointing judges, and I don't think there's any dispute about this, he is required to act in accordance with the advice of the JLSC, see section 104.1. So he has no personal discretion in the matter. And that's the essential background when it comes to considering whether he has any power at the other end in relation to a resignation. So, my lords, the essential question in the appeal is whether, nevertheless, the President had the duty or discretionary power on receipt of the 19th of May letter from the respondent to set aside her resignation or reinstate her. And what I submit is that, with respect to a prima facie valid resignation by a judge appointed by the President's only role is to receive the judge's letter of resignation for the purpose of establishing when the resignation takes effect. And one gets that from a section 142.2, which I just showed you. It couldn't be clearer. And it is, therefore, a unilateral act by the judge. And I say that in the sense that there is no discretion, and it's clear from the words of section 142.2 in my respectful submission, to accept or refuse a prima facie valid resignation. There's no requirement at that stage to consult with anybody, any authority, or to act in accordance with the advice of anybody, as he has to when appointing. And for that reason, I submit, quite shortly, that he has, therefore, no duty or power to inquire into what may have induced the judge to tender the letter, still less to do what Justice of Appeal Jamadar suggested, namely to determine the circumstances, to decide whether it should be given effect to. And I've then set out one paragraph only from the judgment of Justice of Appeal Barreau, who dissented in support of that, which I in turn support. I won't read that to you. It's paragraph 37 of my case, and it's paragraph 22 of his judgment. My lords, I then pick up my argument in relation to the decision of the Court of Appeal at about paragraph 43 of my printed case on page 668. The receipt in my submission of an ostensibly valid letter of resignation is not in any way, shape or form a decision, and therefore it's not a decision capable of review. And since, in the circumstances, as Justice of Appeal Barreau found in that paragraph, there was never any decision by the judge, no question of reconsideration, because that's the way Justice of Appeal Mendonca put it, can or did arise. And it's at that point in my respectful submission that by relying on ex parte Chung and Poe, the reasoning of the majority breaks down. Their reasoning that there was a power to reconsider or revisit the matter presupposed that there was a decision on the part of the President, where there was none. So they effectively, in their conclusions as to the power to reconsider, assumed that which they failed to address, whether there was ever any power in the first place. Now, my lords, can I just take you very briefly, I'm only going to take you to this and possibly one other authority, to ex parte Chung. It's a very short report. It's in the bundle of authorities, volume 2, for those of you with the hard copy at tab 17, electronic page reference 1170. And there's a Times Law report, and then at 1170, there is an official transcript. So I'm going to invite you to look at 1170.
One of those odd decisions, it's been very often cited, but never actually properly reported.
Yes, it is indeed odd, because certainly when it comes to the power of a public authority to revisit or reconsider, it's frequently cited, my lord, yes. At the bottom of that page, it concerned education, the award of educational grants, and at the bottom of that page you'll see that the authorities, last line, were obliged to bestow awards on those who qualified. They were mandatory awards, and the authorities had no discretion in the matter, so it depended on whether somebody qualified or not. If I could then just ask you to turn to page 1173, under the heading the 1978 decision, but not starting immediately. If I could ask you to cast your eyes down to the 6th line towards the end. The Education Act 1962 did more than impose a duty upon local authorities to bestow awards. It also required them to consider applications for awards and to determine whether or not the applicant was qualified. And then I can miss a few lines, I think. Last sentence, I conclude, therefore, that the authorities, in determining that the applicants did not qualify for awards, were performing their duty under the Act, albeit mistakenly. Then this is not to say that having determined that the applicants were not qualified, the authorities had no power to reconsider their decision. I'm sure that they had. It would be strange indeed if a public authority which discovered that it had inadvertently denied a citizen a benefit to which he was entitled could not correct its error. Indeed, I think that it would have a duty to consider exercising this power, although I accept that it would have a discretion as to what action should be taken, and the discretion to be exercised in accordance with the requirements of good public administration. Now, my lords, what I respectfully submit, as I mentioned earlier, is that the Court of Appeal was simply wrong to rely upon ex parte Chung, and it is the mainstay in my submission of their judgment. First, and critically, the decision in that case is premised on the County Council having an initial power, indeed a duty, to consider and determine eligibility for educational grants. Next, my lord, as we've just seen, the Master of the Rolls held that the Act did more than impose a duty upon them to bestow awards. It required them to consider applications for awards and determine whether an applicant was qualified. So, In ex parte Chung and Po, the County Council, on any view, had a duty of consideration and determination. It had made a public law decision as to the applicant's entitlement. It therefore had the implied power to reconsider and correct when it discovered that earlier determinations had deprived the applicants of a benefit to which they were entitled. That was as a result of a decision of the House of Lords. In contrast, in this case, the President neither made any public law decision, nor did he have any power to reverse any decision. And my Lords, apart from the additional argument that my learned friend seeks to derive from the judgment of Justice of Appeal Jamadar, namely that there is to be implied in the 76 Constitution a power of review on the part of the President, that was the decision of the Court of Appeal. That's what it turned on, and it was wrong, and plainly wrong in my submission. And I accept, of course, that this is an appeal from a grant of leave, but if I'm right about that, if that was all there was to this, there'd be no question but that it would be appropriate for this court, in discharge of its appellate function, to stop matters now, because no purpose, public interest or otherwise, would be served by matters continuing to. I will come back to the implied power when I consider the new argument, because it's convenient just to look at it in that context. So can I now come to two discrete points that were also...
Assume one has a sort of case where it becomes quite clear that the resignation has been cured by some sort of duress or fraud or something like that, and the President is made aware of that. You're saying there's nothing he or she can do at all,
well,
not even to refer it to the court, or...
Well, my Lord, there's no power given to him under the Constitution. His function is limited in the way that I've indicated. I suppose in a case where everybody concerned accepted that an obvious fraud had been perpetrated, somebody had delivered a letter allegedly from the judge, but not in fact from the judge, and there was no dispute at all about that, then I suppose by some sort of process of consent between the Judicial and Legal Services Commission and the President, things could simply be allowed to carry on. But that's not this case, and not what your Lordships have to decide. Here, there is an issue of which most of your Lordships will be only too well aware following yesterday's hearing, between the Judicial and Legal Services Commission and the President. And the respondent. And for that, I'm sorry, my Lord.
Well, sorry, I was just going to say it, but I mean, isn't my Lord's example quite important in terms of construction of the Constitution? Because I rather detected in your answer that you would accept that in some circumstances, even though prima facie you've got the resignation under the hand of the officer, that wouldn't qualify as a resignation for the purposes of Section 1422.
Well, my Lord, I accept that if it were proved that that was the case, it would not so qualify. All I said to my Lord Carnworth with respect was that I supposed that it might be argued that there could be a power to allow someone to continue in office in those circumstances. I don't accept that there is, because it's simply not this case and not an argument to which the parties have addressed their arguments. This case is so far removed from that, because what this case involves is constituting the President as a judicial authority, effectively, giving him a quasi-judicial function to determine the circumstances in which the alleged resignation came about. And in no way can any power of that sort remotely be derived from the Constitution, and that's all I need to make good for the purposes of this appeal. So I'm reluctant to go further than that, my Lord.
Yes, sorry.
Can I try another example, which I accept is also not this case, but
Yes.
it sometimes helps to,
Yes.
as it were, look around the edges a bit.
Yes.
Suppose that a person who had resigned, or from whom there appeared to have come a resignation, said that that was void on some ground that didn't in any way affect, in this case, the Legal Services Commission. So there was no other party to have an argument with before the court to sort out the rights and wrongs of that person's allegation that their resignation was void. Bearing in mind that person had been appointed by the President, how would that person establish the voidness of the resignation? Presumably by bringing proceedings and joining the President as a respondent to those proceedings.
Well, I suppose in that situation the President could be the only respondent.
If that's
but that would be, I'm sorry, my Lord, I was only going to say that would be the process, yes, because the President's powers would not enable him to make a determination.
Well, if that's right, is it inevitable in any case where somebody suggests that something which they've done is void, and a particular person here, the President, is the person with whom to have that out with, that other person, in this case the President, is simply said, well, I can't do anything about it, you've got to go to court. Have they got no power or responsibility to consider the allegation of voidness and only have the matter sent to court if it's not clear?
My Lord, I wouldn't accept that there is any power short of having the matter determined by a court, for the simple reason that the President's function on appointment is merely, and I don't mean this in any way to belittle the function, to rubber stamp the recommendation of the Judicial and Legal Services Commission. It is purely an administrative function. And at the other end, upon a resignation, it is equally a purely administrative function, namely to receive the letter, because it has to be delivered to somebody.
But the only difference between the example in which you accept that the President might be the end point of this and something might be done to, let's not mince words, I mean, it could be reinstated, I don't know whether, or declare that the person hasn't been removed. The only difference is the difficulty in establishing the fact in relation to the resignation letter, whether it is void or not. In the first example, where you accepted he might be able to do something, it was easy because everybody agreed. In the last examples, it's not easy to work out whether it's void or not, but is his power different depending on how difficult it is to establish?
I'm sorry, my lady. First of all, I didn't mean to accept that he could do something. I'm
Right.
not quite sure that that's, with respect, what I said.
To accept that.
No.
Because if you get that far, then
Well, that's a
You've made
different.
quite a lot
That's
of the argument.
indeed.
You said, I suppose, that if where everyone accepted the fraud and there was no dispute at all, then by consent...
Well,
the,
my Lord, I did say that, my lady. My lady, all I meant by that was that if the judge simply were to continue in office and nobody take any point,
okay.
then...
Well, what about this analysis, then, that if there's a void resignation, the judge is in office, at worst suspended, and then isn't there a role for reinstatement?
But that would fall to the Judicial and Legal Services Commission, who would have to recommend reappointment upon...
No, not reappointment, a suspension.
Yes.
What's the provision? Can you help
Yes,
me as
forgive
to
me,
what
my
happens on a suspension? Because it's slightly... There's two things, isn't there? One's
there are,
reappoint
yes.
and one is reinstate.
Tab 5, I'm helpfully told, you'll find the Interpretation
Yeah.
Act. Section 39, I think it is,
Yeah.
which is at page 807. I think that's the power to which my lady is...
Yeah, I think it is, yes.
leading. So, subject to the constitutional laws of Trinidad and Tobago, words in a written law authorising the appointment of a person to any office shall be deemed also to confer on the authority in whom the power of appointment is vested. B, power exercisable in the like manner and subject to the like consent and conditions, if any, applicable on his appointment, to reinstate him on his suspension or reappoint him on his removal. So in either case, the critical words are power exercisable in the like manner, and that engages the requirement for the recommendation of the Judicial and Legal Services Commission, upon which recommendation the President is empowered to act.
But that is also stated at the proviso. You can sit over the page. But where the power of appointment is only exercisable upon recommendation, power of removal should only be exercised on recommendation.
Yes. My Lord, I'm not sure that changes anything with respect.
Well, all it seems to be emphasising is that in this case, the relevant person, the President, can only act on the recommendation of the Commission.
Yes, when I said it changes nothing, what I meant is it only reinforces what I've just submitted.
So that's the power of removal.
I'm sorry, my lady.
That's the power of removal.
That is the power of removal.
And it's possibly important, it may turn out not to be in the end, but to keep separate appointment, reinstatement from suspension and removal.
That is possibly right, but that doesn't affect my construction of 39(1)(b).
No, I see that. But then, if I was pursuing this to its bitter end, I'd want to look at the JLSC provision to see what role it has in suspensions.
Yes, well, my lady, we don't have
No.
that, I'm sorry.
Where is the power to suspend?
The power to suspend can only be found through the Section 137 process, which is, I'm going to call it the disciplinary process, as a result of which ultimately a judge can be dismissed, but as part of which he can also be suspended. And I'm afraid we don't have that either, but I can certainly get that for you and have it for after lunch.
I mean, there seems to be a power to suspend in section 39(1)(a) that we're just looking at. How does that interact with section 137 of the Constitution?
My Lord, I think it may be a difficult question to answer without section 137 with respect. So may I perhaps return to it after... I'm sorry? Have you? Oh, I'm told we have it. I'm sorry, I wasn't aware of that. Right.
Well, let's get 137.
Perhaps those could be handed up.
But it looks as the power to reinstate under section 39 is, as you said, in the like manner.
Yes.
And therefore, that implies that also involves the Commission.
That is my submission, yes.
Could you help me with one other thing? In the
Yes, my Lord.
judgment of Chief Justice Mendonca, at paragraph 27, he records that both parties were in agreement that section 142 cannot refer to a resignation that is not valid. Was that concession made below?
Thank you.
My Lord, I'm just trying to...
Paragraph 27.
I'm sorry, my Lord, could you give me the page
Yes,
number?
it's page 600, sorry, electronic bundle 278.
Thank you very much. Well, my Lord, looking at section 142,
Yes.
which you have at tab 2, page 738,
Yes.
what that provides is, first of all, a power to resign, secondly, a method by which it is done, and thirdly, 142.2, the resignation of any person from any such office shall take effect when the writing signifying the resignation is. Now, my Lord, I would accept that if somebody were to challenge in a court the validity of the resignation, and it would be found not to be valid, then it would not be a good resignation. So in that sense,
Right.
yes, it applies to a valid resignation. But so far as the position of the President is concerned, when he receives an ostensibly valid letter of resignation, he has no power other than to receive it. And if it is then subsequently suggested that it was not a valid resignation, as has happened in this case some 3 weeks later, he also has no power to inquire into that question, because that would be to invest him with a quasi-judicial function, which he's simply not given.
So is it effectively as if the letter were never received? Is that how you put it?
Yes,
Well, I think
it's slightly the concept of validity as opposed to a
Yes.
resignation letter by an individual is a slightly odd one. I mean, one normally thinks of validity in the concept of public law acts, whereas this is simply a person writing a letter saying, I resign.
Yes.
But obviously, if it turns out that that was done under duress,
Then it could be set aside.
then it can be set aside for that reason, but not because it's in sort of public law terms invalid in it.
No, but what by validity, I suppose I meant effective.
Yes.
Yes.
And
So
that,
if the court declares it ineffective,
yes,
then
and then
it's
that
not
is
effective.
indeed.
But it begs the question of how you get to that point.
Well, you get to that point by going to the court, my lord.
Yeah, well, you say that.
I say, yes.
You say that.
Why should it always be necessary to go to court? It seems to me that if someone, the reason why the Constitution requires the letter of resignation to be sent to the President is because it's the President who appoints the judge. So there is a kind of relationship, if you like, that the President is the appointor and the judge is the appointee. That can be broken by the appointee resigning.
Yes.
But if the appointee says, actually, it hasn't been broken because the document you received was rather like the blank piece of paper referred to in the recent prorogation case. It was void, it didn't have any effective writing on it. Why can't the public authority, in this case the President, at least investigate, and I don't mean in a judicial capacity, but in the capacity of the person who appointed the judge in the first place, whether the allegation of voidness is made out, and if it obviously is, say, I accept that, so we don't need to go to court. Your analysis seems to produce a situation that regardless whether there's any dispute about it, the person who signs the resignation letter and then says it's void has got to have it determined in court.
Well, my lord,
Courts are there to resolve disputes.
I'm not trying to mince my words, my lord, but what I think I accepted was that, albeit it's not this case,
Yeah.
depending on the precise circumstances, it might not be necessary to go to court. But on any view, in this case, it is. I don't accept that it would not be necessary.
Yes, I mean, there's perhaps the sort of silliest case would be she writes a letter to the President, puts it out, but then wants to think about it overnight, but unbeknownst to her, her husband picks it up and actually sends it off and gets to the President, and then she says, oh, sorry, that was sent by mistake. Perfectly, it was a mistake. Yes. And I'm sure at that point he can say, well, fair enough, we'll treat it as not sent. I mean, that's a sort of silly example, but it's perhaps not entirely inapt because it shows there's some sort of common sense in the matter.
Well, my lord,
but I mean, you say this is a completely different.
It is
where you've actually got to establish some disputed facts.
Yeah, an utterly different case. And the answer to the hypothetical question my lord puts to me doesn't I respectfully submit, lead to any conclusion other than there was clearly no power of the sort contended for in this case. Yeah. And as regards the symmetry, if you like, between the beginning of the process and the end of the process, then my submission is that the JLSC, the Judicial and Legal Services Commission, would have to be involved.
Well, we got that. I mean, we've now got section 137.
Yes, well, my lord's ahead of me. I haven't yet turned it up, forgive me.
Yeah.
And suspensions at subsection 4.
I'm grateful, my lady.
Yeah.
But that's where the question of removing a judge has been referred to a tribunal,
Yes.
which it hasn't.
No, it hasn't, but it's the only circumstance in which, as I understand it, a judge can be suspended as part of such a broader disciplinary process as provided for under Section 137.
Right. Yeah.
My lady, I'm fairly confident in that submission, but Mr. Knox will doubtless correct me if I'm wrong.
So just that I'm clear, as I'm understanding your submission in answer to the question I asked about Section 39
Yes,
of the Interpretation Act, you would say that is displaced in the context of suspension of a judge by Section 137 of the Constitution. Do you remember Section 39?
Yes, my lord, I do.
Was page 807. Section 39 1A seems to create a general power in an appointer to suspend but it is subject to the constitutional laws of Trinidad.
It is, and those laws incorporate, in the case of the appointment of a judge, and by virtue of 39(1)b, any question in relation to suspension and reinstatement, the requirement that the Judicial and Legal Services Commission be involved, because it is all expressed to be subject to the Constitution, generally in subsection 1, and specifically in subsection 1b, to be exercisable in the like manner and subject to the like consent and conditions.
Yes, I was actually asking about 1A.
Well, my lord, that's why I rely on subject to the constitutional laws of Trinidad and Tobago.
Yes, so I think I'm right that your submission about the interaction of Section 137 of the Constitution and Section 39(1)A is that Section 39(1)A just doesn't apply. It's dislodged by Section 137. Is that right?
I think I was being obtuse, my lord, and I think that is what I'm saying, yes.
Right, yeah, I just wanted to make sure that I was understanding. All right, thank you.
I'm sorry for misunderstanding.
No, not at all.
So, my lords, the point I got to was to deal briefly with two discrete issues also dealt with by the Court of Appeal and part of their decision, which I must deal with quickly before moving on to the new argument. And those were, first of all, the public interest point, and secondly, the question whether the President, through the appellant, the Attorney General, should nevertheless be a defendant. The argument, I think I can fairly summarise, is this, that the finding by the court below that it's in the public interest that consideration be given to the President's powers and duties provides a complete answer to the appeal. Secondly, that the board should be slow to overturn such a finding, since it's a finding of judges more familiar with the jurisdiction, and that the board should not decide uncertain points of constitutional law without the benefit of input from the local courts. And moreover, they say that the President is not a necessary defendant. Now, there are several answers to those, and I'm going to take them in a composite way, if I may. First, the public interest issue that was identified by the majority of the Court of Appeal is a question of law, not fact. And my lords, the question of law in this case is whether the President had the power contended for in this case, not with respect the hypothetical scenarios that have been put to me. And if, as I submit, the issue raised is not arguable, then there is simply no reason for proceeding to a full hearing, absent some other special consideration, which I submit there is not. In other words, if the respondent's case as to the alleged power and or duty of the President is not arguable, as I say it is not, no public interest would be served by having a full hearing. It should be decided at this stage. And in my submission, for the reasons I've given, the Court of Appeal was plainly wrong, and that, therefore, subject to the new argument, should be the end of the matter. But secondly, any public interest there may be in having an authoritative statement as to the clear limits, as I submit they are, at any rate in this context, of the President's role, will be served by the Judicial Committee deciding the question now. And appellate courts, my lord, not infrequently decide matters arising from interlocutory applications. And moreover, this is not a case in which no consideration has been given to the question by the courts in Trinidad and Tobago, on the contrary. Thirdly, the public interest in a full hearing more generally will, I submit, be served by the proceedings against the JLSC. Fourthly, in those proceedings, the respondent can obtain the relief in relation to the effectiveness or otherwise of her resignation without the President being a party, including, if appropriate, a declaration that her resignation was void and of no effect. And, my lords, we've said...
I think that would assume that you would be accepting, on behalf of the President, that if there were such a declaration, the President would abide by it.
Well, undoubtedly, but there might not only be, I mean, we deal with redress in our relief in our case at paragraph 63, my lord. It's page 672, and what I've there argued is that it would be open to the court to do a number of things. So I've already said there could be a declaration that it was a void. We've said in that paragraph it would be open to the court to declare that she remains a judge, assuming that to be her wish, but that would be a matter of discretion. Alternatively, if the court considers that she should be reinstated...
Which paragraph is this?
Paragraph 63, I'm sorry.
Sorry, thank you.
Alternatively, and this is the point my lord just raised, if the court considers that she should be reinstated, it could direct the JLSC to advise the President to reappoint her, pursuant to section 104. So either it could declare that it was void, she remains a judge, and there'd be no question but that the President would obviously respect that, or it could direct the JLSC to...
Yes, but if all we're arguing about is whether the President should or could nominally be a party so that he is technically bound, I don't suppose we'd be here. I mean, the reason why we're here is the suggestion that the President has some
purpose, some role.
some substantive reviewing role.
It is, my lord, yes. But my lord, I would just add that if one looks at the relief in this case, the relief sought, which one finds at volume
if
1.
you're moving away from your paragraph 63, can I just ask something about that?
Yes.
In terms of reinstatement,
Yes.
Pursuant to section 104 and 143,
Yes.
that would be from, well, the future, whereas what she wants is she's been in post the whole time. Is that not right?
Well, that may well be what she wants, and it's for that reason I say that it would be open to the court, so to declare, but as my lord will know, we've put the two cases in the bundle. There are a couple of cases, one's
I
evidence.
mean, surely this is all... I mean, if the court gets to the point of deciding in her favour, then at that point the court will no doubt be able to sort out what's the appropriate remedy on her submissions on it, but
yes, my lord.
hardly useful for us to discuss that now.
My lord,
Well,
yes.
I just wanted to understand whether you were saying that reinstatement could involve reinstatement from the point in the past, from 19th of May 2017.
It would be at large, the relief.
Oh, sorry, 27th of April 2017, forgive me.
It would be entirely a matter of discretion, the precise way in which the relief was framed.
No, but the question of the specific example you give
Yes.
of reappointment
Yes.
under section 104 or section 143, I just wanted
Then-
to clarify, you're not saying they could reappoint as from 27th of April 2017 under those provisions? No, okay, thank you.
There is obviously reinstatement and then there is reappointment.
Yeah.
And I
Just wanted
was
to clarify that.
clumsily seeking to distinguish between the two.
Yes, thank you.
For reappointment, wouldn't there have to be the process gone through?
There'd have to be yes, and a recommendation.
It has to be consultation, recommendation, and so on. So
Yes, there would.
it's slightly problematic for the court to direct that the Commission recommend it.
Well,
it shortcuts
all I
them?
can say is that Section 14 of the Constitution, which relates to constitutional relief, which is what is sought here, and there are any number of the decisions of the board that have said this, is in the widest terms and enables the court to make directions that one might not immediately think would be open to a court. So it is possible that the court could do that.
Yes, but I mean, I don't think we're at least... I'm not sure. I can't at the moment see how we can get involved in that. I mean, the first question is to decide whether she's right in substance.
Well, all as your lordship and my lady know, you have to decide is whether the point was arguable or not. I mean, that's all. All I was seeking to do here, in response to the question whether or not the President should be or needs to be a party, was to demonstrate that there are a range of remedies that could be granted, and none of those would require him to be a party insofar as we are engaged in considering that. It's
None of them are reasons for him not to be a party.
well,
I mean, there we are. But I mean,
one could take that view, but
I mean, similarly in our prerogative case we had the other day, we could have the Queen is nominally a party anyway because the proceedings are brought in her name. But
yes,
we were in the end declaring that her order in council was a bit of waste paper. Now, in the similar context in Trinidad, I'd have thought the governor might want to be party to her bit of papers preparing ways here. But I mean, I just don't see why we're going down that route, because it's not what you're here to argue about.
No, it's not, my lord. Can I though? I mean, since we are, can I just ask you to look at the record, volume 1, at page 9.
Electronic.
Oh, I'm sorry, my lord. Page 9 is the electronic number.
Thank you.
Funnily enough, it's 85 in the record. So.
Page 9.
Page 9, yes. The constitutional relief sought as regards the President is at 14, a declaration that the President infringed the applicant's constitutional right to the protection of the law as guaranteed by Section 4B of the Constitution. And then at 16, a declaration that the resignation or purported resignation was of no effect. And then an alternative. It also included, at 15, I should have said, damages. Now, that is relief sought specifically against the President on the basis of an alleged infringement by the President.
Yes, but
if I'm right, yes, my lord, but if I'm right, and there was none, there is then no claim for damages other than against the Judicial and Legal Services Commission. And for reasons I've suggested in my case and we've just been discussing, there is simply no need for the President to be a party at all. Well, I'm sorry to labour the point, but...
I understand.
Well, since you are, can I just raise a point then on point
six?
Well, I mean, but since, sometimes you seem to be accepting, that the President would accept a declaration and so on. There isn't a formal undertaking. Just on the declaration at 16, since the President is the appointor, and since a declaration is a declaration of right between particular persons, at the moment, speaking for myself, I would have thought that the President was formally a necessary party because the right which is being sought to be declared is whether the appointment by the President is continuing.
Yes. Well, my Lord, if your Lordships were with me on the arguability point and he remained a party for that purpose, that I accept. It probably wouldn't matter, but for what it's worth, my Lord, I wouldn't respectfully accept that he is a necessary party simply because the actions alleged concern the JLSC. The complaint is that they subjected the judge to duress, and that if that is found to have been the case, a finding is made to that effect. Then one asks, what is the effect on her resignation? A declaration is made in one of the forms which I have suggested. Let us suppose it's void, and that she therefore continues to be a judge. There would be nothing whatsoever for the President to do in those circumstances. He would simply...
Well, other than acknowledge that his appointment of her continues.
Well,
yes,
but that would be the effect of the court order, my Lord.
It seems to me that we're talking about, for the moment I see the point my Lord is making, that as the declaration would be directly relating to something the President has done, then the subject is he's a proper party. Whether he's a necessary party is another matter. But
well, as a matter of form, I see the force of the point.
Okay, I think we've got that. Now, where do we go from there?
My Lord, can I then come to the new argument?
Yes, and you, not quite sure what the new argument is. Would it be better to hear Mr. Knox try and persuade us that there is a new argument?
I'd be very pleased for your Lordships to take that course, if that's what would be appropriate.
I don't know what
but I'm equally... My Lord, can I indicate what I was proposing to do, in case it informs the Board's decision? I was proposing fairly shortly, 15 or 20 minutes, simply to set out why I say, based on the statutory provisions, the point is unarguable. I was not going to get into the interpretation acts, which Mr. Knox goes into. I was going to leave that for reply, but I would, of course, be happy to respond if that suits the Board better.
Well, I think let's hear your quarter of an hour, as long as that's what it is.
Well, I think I said 20 minutes, and I'll try and stick to that.
Anyway, you're well within your time.
I think I am, but I don't want to take longer than I need,
No, I don't want
if
to
I'm allowed.
give you the impression I'm trying to rush you.
No, you're not, my Lord. The starting point, my Lord, is this. If the common law rule regarding acceptance of a resignation, which Mr. Knox seeks to rely upon for his argument, does not apply to a High Court judge in Trinidad and Tobago, then his argument cannot, with respect, even get off the ground. Now, he has relied, and I'm certainly not going to take you to all of this, on a passage in Halsbury's laws as authority for the proposition that, it's paragraph 30 of his case, by virtue of the prerogative, the resignation of an office held under the Crown was not effective until it was accepted. Now, we have set out in our further submissions in response, which you have, the full passage. That's the easiest place to look at it, I think. So it's my submissions in response, paragraph 9. I don't think this has found its way into the electronic, well, it probably has, but I don't know what the page number is again, I'm afraid. I'm very sorry.
This is a document called
Appellant's Further Submissions.
Appellant's Further Submissions.
That was served yesterday. That's the one.
Yeah. Everyone got that? Yes.
So in paragraph 9, I've set out the full extract from Halsbury's, which Mr. Knox relies upon. It seems that at common law, any person appointed or elected to a public office, the duties of which had to be performed in person, was under a legal obligation to serve. Refusal to serve was a common misdemeanor. It would appear that, in the absence of a contrary intention, resignation from an office held under the Crown is ineffective until accepted. And then Halsbury goes on to give some examples of that, and I'm not going to take you to it, but one example is in the bundle. It's a case of Hearson and Churchill at tab 1. And further and more detailed consideration was given to both these older cases referred to in Halsbury's, the nature of tenure at pleasure, and the common law rule, in various contexts, in a case called Marks and the Commonwealth of Australia, which you've got at tab 2. And my Lord, I've given the references to the case, and in the interests of not taking up your time, I won't take you to it at this stage, but simply develop my argument, if I may, by reference to what I have set out from Marks in paragraphs 12 and 13 of my note.
Sorry, that's tab 2.
Tab 2, to give you the full reference, my Lord, it's tab 2 of my further authorities, so it's not tab 2 of the bundle of authorities.
Appellant's supplementary bundle.
That's the one, yes. Appellant's supplementary bundle of authorities.
Yes, thank you.
Well, my Lord, shall I just take you very briefly to the extracts? Would that help? If you have the report, first of all, in relation to the common law rule, at page 6, the judgment of Justice Menzies. I won't read it in the interest of saving time, but starting in the middle of the page, I am in no doubt that, and if the board would kindly just read the next 10 lines to themselves.
Yes.
Then to same effect in the judgment of Justice Windire at page 11, starting at the foot of the page, just for your reference, the very last line on the left, but for a resignation of an office to take effect, it was necessary that the person under whom the office was held, king, bishop or corporation, should accept the resignation and so on, down to vacated until it was accepted. And then could I just ask you to look at that same column on page 11, nearly 2/3 of the way down, whatever was the position in former times, the rule that resignation of any office only takes effect upon acceptance, and that there cannot be a unilateral resignation has in modern times become attenuated. It has come to be used for a withdrawal from a contractual relationship and so on. And then at the bottom of the page, he takes various examples, and only for interest, nothing else, over the page at the top, he refers to the position of judges in this jurisdiction and indeed members of the Judicial Committee of the Privy Council being permitted to resign and so on by giving notice. And then page 12, right-hand column, penultimate paragraph, the varied statutory provisions quoted above show that today the vacation by resignation of an office or place does not always require or await consent, but that sometimes it does. Whether or not it does depends in each case upon the terms of the particular statute, and so on.
I mean, what's that got? I mean, here we've got a statute which says that resignation takes place on receipt.
Precisely, my Lord. This was only by way of background to the common law rule. Can I literally just give you the two other references without reading them so that you've got them? It's page 20, second paragraph, right-hand column. And finally,
So I suppose you have no electronic numbers for any of this.
No, I don't, my Lord. I'm sorry.
Pacing through as fast as I can.
I'm so sorry, my Lord. So internal page 20. Right-hand column, second paragraph, the common law rules, etc. And then just that paragraph. And then finally, internal page 23, right-hand column, paragraph begins in considering whether, but it's the second half of that paragraph after the reference to Baron Wilde, but much of what was said in Reg and Cumming and so on, down to the end of that paragraph. My Lord, that's only the historical background, which we thought it right to put before you, bearing in mind the reliance on Archbold. But the point I was making, and which I'm now going to turn to in looking at the provisions,
Just before we do it, it's just to call attention on page 12.
Yes,
actually, in the left-hand column, the provisions under review there are actually very similar to Section 142.
They are.
And they're taken by the Australian court as examples of where there's a particular provision saying it's a right of the office holder to terminate the relationship. Right. They can do that.
That's right.
Which is what you say
exactly
is Section 142.
Indeed. This illustrates that point, and to an extent is authority for that point. But more than that, it's really only a review of the historical position, and I hope of some assistance, but I don't rely upon it as much more than those two things. The real point was the passage I've shown you, I set out in paragraph 9, that Archbold envisaged, not Archbold, Hawkesbury's laws envisaged the possibility of there being a contrary intention, and that, in short, is what, in our respectful submission, is absolutely plain from the Constitution. Now, just to develop that as briefly as I can, these orders in council, the 1961 and 1961 and 1962 constitutions were made under the prerogative. Section 95 of the 61 Constitution and its successor, Section 103 of the 62 Constitution, in our submission, displace the common law rule or leave no room for the common law rule. And that's really a consequence of the sovereign having first divested herself of the power to appoint judges, which is the very basis of the common law rule that Mr. Knox seeks to rely upon, and expressly, and this is key when it comes to Section 142, expressly empowering judges to resign and stipulating what's required if they want to resign. And the present position, of course, is Section 142 of the 1976 Constitution, but they're all of a piece, all three of those constitutional instruments. So accordingly, what I respectfully submit is that any argument based on the common law rule that resignation of an office required acceptance is unsustainable, because the rule was displaced by express constitutional provisions covering the same subject matter. And turning back now to those provisions, which we've looked at, both section 103(1) of the 62 Constitution and section 142 of the 76 Constitution empower the holder of such an office to resign and provide for the method in which they do that. And then, in subsection 2 of each of those sections, respectively, provision is made to the effect that the resignation shall take effect when the writing signifying it is received. And the effect, as we saw, of section 95 of the 1961 Constitution, the wording being slightly different, was exactly the same. So, since at least 1961, we submit, permission has not been required to resign an office established by the Constitution. And my lords and my lady, if consent or acceptance were required, that really being Mr. Knox's premise, there would be no power to resign, the very thing that the sections provide. So, in short, in the case of a judge of the High Court in Trinidad and Tobago, a resignation that meets the explicit requirements, of course, of section 142 is effective from the moment of receipt by the person to whom it is addressed and to whom it is supposed to be addressed. It is, therefore, a unilateral act done pursuant to an express power. It does not require consent or acceptance. And to put it bluntly, there's nothing more for anyone to do. There's no role for the President to play other than to receive the document.
Do we have the letter she wrote, some of the papers?
No, but we have the President's response, and that is in volume 2 of the record at page, well, I'm told we do have it, I'm sorry. Oh, I'm very grateful. 467.
That's her letter, is it?
I thought my Lord was referring to the letter of resignation.
Yes,
Yes, this is not the letter of resignation, Peter. We don't, my Lord, but if your Lordships turn to page 513, we find the President's response, and that quotes that which, inter alia, the letter said. And that's the best evidence we've got.
Yeah, I see.
So, my Lords, for the reasons that I've already ventilated, in summary, the President therefore had no power upon receipt of the letter to set aside the resignation or reinstate her,
Yes.
or, as it's now put, treat it as withdrawn. And, my Lords, I said I'd return briefly to the argument which is said to be what Justice of Appeal Jamadar was also saying, namely that you could imply some such power in the Constitution. My answer to that is that the former prerogative power of appointment and the common law rule on which Mr. Knox seeks to rely cannot of themselves afford a basis for implying such a power. One has to look at the instrument concerned, the Constitution.
Yes. Right.
And it's clear as day that they've been displaced, and that any implication such is contended for would be completely at odds with the limited power that the President has in the process of appointment. And, as I've argued at any rate, based on section 39, the need for the JLSC to be involved again if one's talking about reinstatement. My Lords, finally, can I just make one other point? If, contrary to the appellant's submissions, my submissions, acceptance of the respondent's resignation was required, somehow in accordance with the old common law rule, the respondent has, with respect, provided no authority at all for the proposition in paragraph 32 of her case that the Crown ever had a power to accede to a request for a resignation to be withdrawn after it had been accepted and therefore taken effect. Because what the common law rule provided was that it became effective upon acceptance. There was a period during which the person to whom it was given could consider it. And only to repeat one thing I've said previously, but it's very important in my respectful submission, the extension for which Mr. Knox is contending is a power after that point, even on his own case, which requires the court to invest effectively the President with an investigative power or quasi-judicial power. And my Lords, that is, in our respectful submission, simply impossible. I think I've done it in 20 minutes. I haven't said anything about the Interpretation Acts, and I reserve my right to do so if necessary. But I can do that in reply. Unless there are any other questions, those are my submissions.
I think not. Thank you very much. It's very clear.
Thank you, Mark.
Mr. Goldblatt, do you follow? Right, Mr. Knox.
My Lords, I have three propositions on the main point. The first is this is a second appeal against the grant of leave. To my submission, there's nothing wrong with the Court of Appeal's approach to the effect that the respondent's case is arguable. And my Lords, we've had two of the, I think, most senior judges in the Trinidad Court of Appeal come to that conclusion. They've given careful consideration to the effect of Section 142. And I submit that it is not right on a second appeal to try to resolve what undoubtedly is a very important point of law, which affects not just judges, but any number of officers, however one construes the Constitution, any number of officers in the Constitution. Second, I submit that in any event, the Court of Appeal held that this is a matter of considerable public importance, which should be subject to a full review in the public interest and indeed in the interest of working out what the President's powers are in this type of situation. Thirdly, even if one considers the point de novo, I submit that the point is properly arguable. First, I say so for the reasons given by the Court of Appeal, to the effect that there is an implicit power in the President to review whether there has indeed been a resignation within the meaning of Section 142 of the Constitution. Although the Court of Appeal does not say what the source of that power was, it was, in my submission, self-evident, and they would have been aware of it. That is to say, Section 74 of the Constitution, which is the provision which provides for the President's executive powers. Secondly, I submit, quite apart from that, the point is arguable for this reason, that the President has a power, both A, to accede to a request to withdraw a resignation before the expiry of the notice period which it gives, and also a correlative power to accede to such a request afterwards, at least when it is apparent that the office holder is alleging duress or indeed some form of serious error or mistake or misapprehension. And I say that such power was first of all part of the common law and prerogative powers. Secondly, it has not been cut down by the Constitution or any of its predecessors. And I emphasize this, that power to consider a request to withdraw a resignation, whether before or after the notice period, survives whether or not the President has lost his power to reject a resignation. They are not dependent at all. Those powers are quite different powers, and there's a fundamental difference between those powers and the power to accept or not a resignation. The power to accede to a request to withdraw a resignation before or after is manifestly for the benefit of the office holder. It doesn't follow, whereas what the effect if my learned friend is right, of Section 142 is to confer another benefit on him, an automatic right of resignation without acceptance. And I submit that it doesn't, so I'll put it another way around. You have one benefit conferred by Section 142 on the office holder. You can resign as of right. It certainly doesn't follow from that that the office holder has lost the power to request the President, in this case, to withdraw a resignation before expiry of the notice, or indeed afterwards.
But I'm sorry, this is a quite new point, isn't it? I mean,
Well,
I'm not quite sure which hasn't been considered by the Court of Appeal.
No, well, my lords, that point itself, we certainly raise this point in our case. We say, we give examples of how odd it would be.
What I'm not understanding is, this is, you're saying, quite apart from whether there's any complaint about the way the Chief Justice acted, if a person who's resigned then thinks better of it,
Yes.
they can ask the President to reinstate them.
Well, there are two periods, because I do want to come to there's one very odd feature about Section 142. It appears to presuppose that the only type of resignation you can give is one without notice. I submit you've got to look into the common law background.
No, but I just want to see where you're going.
Yes.
What criteria is assume she just comes along, she says, sorry, I've decided better, I want to remain a judge.
Yes.
And you say the President can simply say, well, that's fine, back you go.
He has a power to do so.
And
yes.
without any provision as to what happens to her in the meantime, her decided cases.
Well, my lord, there are two questions. The first is the request to withdraw a resignation before notice has expired. Let's say I give 2 months' notice. I'm resigning on the 1st of January. Now, within that period, I submit there always was at common law a power in the office holder to ask for the resignation to be treated as withdrawn, and, importantly, a power in the President to say, yes, I'm satisfied. A power, not a duty. I'm satisfied.
Yes, but I mean, there's nothing in this statute which would stop that. There's nothing in the statute which deals with what happens if you resign in 2 months' time.
That's my lord, that's my point.
Yeah.
I say there's nothing in the Constitution that affects that power to allow
Yeah, but
resignation.
that's not this case. She resigned forthwith.
I know, that's different, my lord. I'm simply on the point of principle here before I get to the point on the facts. But the point of principle, I submit, is very important. Namely, an office holder can withdraw a resignation with the appointeur's consent before the moment of expiry. And I say that gives the lie to a literal construction of Section 142. I submit it obviously is not intending to deprive the office holder of that ability, or indeed the President or the appointeur of that ability. That ability is one that survived, that was a common law right, if you like, on both parties, and that right survives before expiry of the notice. Now, my point is this: there was always a correlative right after expiry of the notice, simply by virtue of the President being what you might call an entity, or the Crown being an entity, to accept after expiry of the notice that a resignation was procured by duress and say, oh, I see, I'll accede to that. There's a power in him to do so. That's my point. And that power is not dependent upon his power to reject or otherwise a resignation. That power is a corollary to his power to accept a withdrawal of a resignation. And that power, in my submission, is not affected by Section 142 at all. And I'll come on to the importance of the question of how one construes constitutions, and indeed how one should work out whether prerogative powers are being cut down by statutory or constitutional provisions.
But I mean, doesn't that power that you're now arguing for after the resignation has taken effect potentially cut across the constitutional provisions on appointment of judges? So suppose the resignation has taken effect. The whole machinery of appointing a replacement judge has whirred into action. A replacement judge has been appointed, and then the first judge says, well, please accept that my resignation was not effective.
My lords, it doesn't, in my respectful submission. It obviously cannot be, if I can put it this way, the President could not exercise such power in such a way as to for instance, in the example you give, another judge has already been appointed, that he would have a power, but he would no doubt exercise his power by saying it would be inappropriate for me to do anything in these circumstances. My lords, I'm simply on the narrow point for the moment of the President's powers, rather than by reference to a given situation. But my primary point, my lord, is that he does have a power to accept a withdrawal of a resignation. Whether or not it's appropriate in the circumstances to do so is another matter. And my lords, can I give an example which I hope goes some way to answering my Lord Sale's point? Supposing you have this situation. Letter of resignation is handed in with immediate effect. It turns out, a few weeks later, that the office holder says, that was given under duress. I was told my children would be killed, and I had to do this, and please accept that. And the President says to himself, well, I must say, this is all pretty compelling stuff. I don't see any it's obvious to me that this was given under duress. And he gets in touch, let's say, with the Judicial and Legal Services Commission. And he says to them, look, I've got this problem here. There was obviously a resignation that was procured by duress. What do you have to say about that? And they might say, yeah, looks to me like that. And then he says to them, well, tell me, what do you think about, my allowing him to come back in? Supposing they said, well, we're neutral. We have no particular views on this. We don't think he's much cop as a judge, actually. And if he was to sort of go through the appointment system all over again, we wouldn't appoint him. But that said, we're neutral. Now, in those circumstances, the President, in my submission, would, this is the crux of it, would have a power to say, well, I accept the resignation was procured by duress. I'm not reinstating you on the advice of the JLSC, because actually they're not giving any advice about reappointment at all. But what they would be doing is simply acquiescing in that. And I say exactly this situation, this type of thing could have happened in this case. The President could have got in touch with the JLSC and said, well, this is terrible. My own view is that I remember when I saw her, she was crying. All this looks pretty compelling to me. What do you have to say? Now, it would have been open, in my submission, and this is the point in the case, it would have been open for the Commission to say, well, look, do what you think best. We're neutral. And had that been the case, the President would, in my submission, have been within his rights, constitutional rights, to say this resignation was invalid, and I am therefore not, in any meaningful sense of the word, reappointing this judge. I'm simply accepting that she never resigned in the first place, and that is within my prerogative to do so. That, I submit, is the example which one has to bear in mind in this case. Supposing the President accepts the facts that are alleged, the Judicial and Legal Services Commission says, well, I'm neutral about those facts, although I wouldn't myself recommend a reappointment. My submission is there is a power, and certainly, my lords, what I submit is this. This is arguable, because we're not just here talking about judges, we're talking about a whole range of officers.
Yes, well, you made that point. Yes. And I mean, that's, you say, is where essentially what the Court of Appeal was saying was arguable.
Yes.
But I was a little concerned, you seem to be going way beyond that with your new point. And I just wanted to be, do we have the letter that your client wrote on the 27th of April? The one asking the President to reopen the issue.
We've got the reopening letter at the 19th of May.
Well, no, we got the one, the one, yes, 19th of May, well, that's right, the one reopening letter. Where's that?
I thought it's at 467.
Yes.
My Lord,
467.
in case it assists, I'm told that the letter of resignation is in the record from yesterday's appeal at page 977. Well, it may assist my learned friend if he has those papers. Yeah. Page 977 of yesterday's record.
Right, well, that's helpful to know. I mean, if anyone, does anyone have it in court, in fact? Because if they do, it might be helpful to get a copy of it.
But what page did you say it was?
977.
We do have electronic access to it, so.
What page of yesterday's bundle?
977, my Lord.
977, well, we can get that up. Anyway, as far as today's proceedings are concerned, the letter of the 19th of May is on page 467. Yeah.
My Lords, I accept that the letter of resignation that was handed in on the evening of the 27th of April
Yes.
was with immediate effect.
Yes.
But I say that doesn't matter on the facts of this case, because all one needs to know is that there's a power to accept the request to withdraw a resignation both before and after the notice period. And that applies whether you give no notice or not. It's a power vested in the President. And in my submission, and it's a point that's made by Mr. Justice of Appeal Mendonça, I'll come to my more specific submissions. This is obviously a power in the public good. Very difficult to see why this power is a power which is inconsistent with the Constitution. I would accept this much. It could not be exercised in a manner that was inconsistent with the Constitution, and that might give rise to problems were the President to seek to do so. But we're not in that territory in this particular case.
I was just seeing what she actually asked the President to do, and we have that on page 25.
What happens is she sets out
475 to 6, and she says she sets out her complaints about the pressure and so on, and she said it was unconstitutional and of no effect, and so she's effectively
and para
asked.
36, at the end, I think you mentioned.
That's what she's doing, yeah.
Yeah.
Thank you.
So, my Lord, that I submit is the issue in the case. Can I just also take you to the agreed statement of facts and issues, because in my submission we are on a point of law here. We're not looking at the facts. The issues are summarised at paragraph 27, and they're essentially issues of law, rather than questions of what you might call, in the circumstances of this case, what was the appropriate answer. And if I can take you, it's electronic bundle 653. I don't think issue 1 is of much importance in a way. Issue 2, did the President make a decision or omission in relation to the resignation that's capable of review? In particular, A is put in what I would submit a fairly tight terms. Did he have a duty of description? Did he have a duty to set aside? And then, according to the respondent, did he, on receipt of the letter, at least have a duty or power to investigate and, subject thereto, to take any steps in relation to her allegations? Did he have such a power? And then the appellant says that issue would arise, but only if he's got a power to set aside. So again, my lords, those are the issues, and that's what I've come here to argue. And then subparagraph 3, whether in the circumstances the President erred in law in refusing to take any steps. Now, my lords, our position is, well, he did err in law in that respect. There is, of course, another question, which is a question for the final hearing, which would be, well, even if we're right on all these legal points, was he in fact justified on the facts in saying, well, look, there's nothing I think it would be appropriate for me to do. That issue, my lords, is not, my lords and my lady, is not before you on this appeal. And my lords, it's not actually an issue that seems to be ventilated in the Court of Appeal. There's no sign of that in the Court of Appeal's judgment. And it hasn't been suggested that the Court of Appeal erred in law because they failed to consider such a point. So, my lords and my lady, I submit we are here on a narrow point of law about whether a power exists in the first place, rather than would it have been appropriate to exercise that power. My lords, can I turn to my first point, and that is the question of leave. My lords, I do submit it is important that two courts below have found this point to be arguable, and they've considered it. The judge, it may be only towards the end of his judgment, but the Court of Appeal, and I submit a very careful judgment. And in those circumstances, I submit it's not right for this board in the exercise of its jurisdiction to revisit the point, unless I would accept this. It's absolutely plain and obvious there's an error. I would accept if it's something you could say, well, really, the Court of Appeal's just totally missed something, then, my lords, that might be different. But in my submission...
but surely, I mean, if, as Mr. Stevens says, the President was advised that he or she had no separate power to investigate the matter. Yes. Now, if that's correct as a matter of law, and we are satisfied that's correct as a matter of law, then we better well decide it. But, I mean, there's no point, if we think the law is clear, there's no point in sending it back for further
I accept
if,
that.
on the other
Yes,
hand,
if it's clear, yes.
Sort of uncertain,
Yes.
and the matters which we would wish to have further assistance from the local courts, or we think is proper from the local courts, and obviously you will get leave and on it goes.
Well, my lord, I accept that. But my lord, I submit, at best, one's in the second category of the two categories you gave. This is not something that be said to be stone-cold certain what the answer is. And my lords, you'll be familiar with the authorities to that effect. My lords, at electronic bundle page 51, there's a reference to what Lord Diplock said. I can't remember which case it is now, but there's a short summary of what he said. And in E19-1234, there's a reference again to what Lord Diplock said.
I think we've had quite a lot of experience of judicial review since
Lord
Diplock's great words.
Well, my lord, but obviously I want to emphasise it, because is it something that just strikes one immediately as wrong? Well, not really. The sort of thing one needs to look at. My lords, the other point I do submit is that the judges in the Court of Appeal exercised a lot of care over this matter, and in particular, if I can just ask you to look at the Court of Appeal's judgment at E278. This is in the judgment of Justice of Appeal Mendonça, E278. At paragraph 27, paragraph 27, both parties were in agreement that section 142 of the Constitution cannot refer to a resignation as not valid. I think that's a perfectly legitimate concession. And then he continues, it would seem that an invalid resignation must include one that's been obtained by duress or undue pressure, fraud, forgery, or other means. It would be extraordinary if the effect of section 142 was to bring about the effective resignation of an officeholder on the receipt by the President of such an invalid resignation. And then, accordingly, section 142.2 refers to the effect of the resignation can have no application in the face of such a resignation. And section 142 of the Constitution therefore cannot be invoked to establish that the effect of such an invalid resignation and that the President, having received such a resignation, has no further part to play and can do nothing if notified that resignation was invalid. Now, my lords, in my submission, that is a perfectly arguable position.
Yes, what they don't go on is to say what he should have done to investigate the position.
Well, my lords, that's because it wasn't before them.
Well, yes, but one's got to consider what sensibly he should have done other than to refer the matter to the court.
Or, my lords, my lords, my lady, because this is a point that Mr. Justice of Appeal Mendonça says, I think, a little bit further on, at page 282, the final line, paragraph 34, they are alert to this point, although it might be tempting to look back and say that anything the President did could not have avoided these proceedings, the fact is that one can never be sure what a timely intervention in a less adversarial setting might have achieved. If the President has the power, which I've said is arguably has, then by not recognising and taking appropriate steps, the respondent was denied that benefit. It is, as I said, arguable that to do nothing was not appropriate. So, my lords, he's not saying that...
I don't quite understand how that was meant to work. I mean, he says, oh yes, I think there's probably a case that the Chief Justice has
overstepped the mark, let's say.
Overstepped the mark. So what did he do? Go back to the Chief Justice and say, reconsider it?
Well, he could do that, or he could go to the Judicial Legal Services Commission and record his own view of the matter. And, my lord, it's not an entirely unrealistic point, because he was there at the moment the resignation was handed in, and he advised my client not to commit suicide.
Well, it's very emotional. Very emotional.
It's a very, very striking case. So it's not a case where he would be, so to speak, be speaking from a position of total ignorance.
I think the other judge went further, didn't he? Jamada J.A. said he actually should resolve the matter.
My lord, I'm not quite sure if he went quite as far as to say he should resolve. He should have resolved the matter. But my lords,
what are you saying he should have done?
Well, my lords, what I say he should have done, and he could and should have done, he should have recognised he had a power to do something. That's the first point, and that he erred in law by holding that he didn't have such a power. Secondly, if one gets into the question of what should have happened on the facts of this case, I would submit he should have made appropriate inquiries. Now, you might say, thanks for that vague phrase, but that would no doubt cover making inquiries of the Judicial and Legal Services Commission and those involved in the resignation as to what had happened, and then seeing whether a settlement could be reached. And in my submission, that would, and then if, let us say, we have exactly the situation that I put to you earlier on, he said, and it was common ground that there had been inappropriate conduct, then he would have had a power, at least if the Judicial and Legal Services Commission didn't object, vociferously maybe, to say, well, I'm accepting that there's been a resignation, an invalid resignation. If, let us say, what had happened was the Judicial and Legal Services Commission said, look, we didn't apply any unlawful pressure whatsoever, and we stand by our guns on that, then, my lords, I accept. It might have been on the facts, it might then have been inappropriate for him to say, well, I'm going to say this was an invalid resignation. On the facts, it would then have been appropriate, no doubt, to say only the court can decide this, and I'm not going to step into the shoes of the court, where there's a manifest conflict between what the judge is saying and what the commission is saying. But I do submit he would have had a power to get things going in the first place and see if a settlement could be reached, certainly.
But I mean, that sort of takes on to another thing that troubles me, is that all this is water under the bridge, in a sense. I mean, I'm slightly surprised your client has sort of got involved in this, because your presumably the desire is to sort this out as soon as she can. And, once, if it was all the President ultimately could have done was to say, well, you must get it sorted out by the court, that's what's happening.
Well, my lords, if that's all he could have done, the trouble is at this point, that part of the inquiry hasn't been begun.
No. But I mean, what's in it now, given that the court, everyone accepts this has got to be decided by the court, and we've decided yesterday that there can be a cross-examination, so the facts have got to be looked into. What's the advantage to your client of the President being involved, or any decision about what the President might have done 2 years ago?
Well, my lord, I suspect that the origin of what you might call the unusual procedural position we're in is that my client brought a claim against the President on 2 grounds, essentially, and one of those grounds was dismissed, but the other not. And then the Attorney General appealed on the ground that was left in, and that was resisted. No doubt, my lords, because there would be cost implications in it. But, my lords, if you ask what is the long-term practical advantage of having the President in, my lords, I think I'd be driven to accept that, subject to the importance of his being a party to the action for the purpose of relief, subject to that, it may be that the point doesn't take my client's interests very much further, because either she wins against the JLSC or she doesn't. If she does, it's difficult to see what else she's going to get from the President, except possibly damages for not considering her complaint. But that's about it. But I do accept, my lords, but my lady, it is one of the features of litigation that sometimes you get odd bits lying around, which perhaps could have been dealt with in a different way.
The trouble is, as you say, this is a potentially important issue affecting all sorts of people, and deciding a point which is effectively academic by the time it gets to us is
my lord, if that were the case, of course, that might be a point in my favour. But everything's academic. But my lord, that is.
Okay.
You have my answer to what I say. The issues in the case are why it's terribly important to focus on what they are. My lords, as far as Justice of Appeal Jamadar is concerned, can I just draw attention?
I've now been handed her resignation letter, and it's just very straightforward terms, as we
yes.
just says she tenders her resignation.
Yes.
Thank you.
My lords, Justice of Appeal Jamadar is at 296, paragraph 27.
Yeah.
Paragraphs 27 and 28. He tests the Attorney General's proposition by reference to various examples, in the same way that Mr. Justice of Appeal Mendonça did, mistake, forgery, and so forth, lack of authority. And paragraph 28, his conclusion must certainly be arguable with a realistic prospect of success that for section 142 to be operative and effective, what is required is a bona fide, legitimate and voluntary resignation that also meets the substantive requirements of form and process prescribed by the section, and so forth. Indeed, in this matter, it is exactly this issue for which leave has been granted to examine and review. And then paragraph 31, page 297. What then are the implications for the President in this matter? First, it must be seriously arguable that the President is only governed by section 142 of the Constitution if what was delivered to and received by him was in fact in substance the lawful and voluntary resignation. Second, if it was not, then it is arguable that the President was not constrained by section 142, was not therefore functus officio, and had a continuing jurisdiction power, even duty, to at least meaningfully to consider the substance of what the respondent had raised in her letter of the 19th of May. That's it's arguable that the powers of consideration, review and recall, or rejection, may all be powers that the President had in this matter and did not exercise in the mistaken belief that these were powers he didn't. Third, it's arguable that for resignation to be effective, it must be a free volition and so forth. And finally, paragraph 34, he goes on to make the point based on the public law principle of correction and consideration and correction, the President arguably had a power to meaningfully consider what the appellant had brought to his attention. And I submit, my lords, my learned friend said there was no support for, he said the case of power and chewing doesn't really help very much in this case. Well, my lords, I submit that's not quite right, because if I'm right in saying that the President always has the power to consider a request to withdraw a resignation before it is accepted, and it takes effect, rather, before it takes effect. Likewise, under the power to reconsider, he has a power to accept, accede to a request made after the notice period has taken effect. I submit that is certainly arguable. Now, my lords, I accept this much. In the Court of Appeal's judgments, neither Mr. Justice of Appeal Mendonça nor Justice of Appeal Jamadan, nor in fact Mr. Justice of Appeal Bureau, advert to what they say the source of the President's power was. They don't say, where's he getting this power from? Say, it's obviously in the Constitution, that must be what they're saying, but I do submit that it is obvious that what they are referring to is section 74 of the Constitution. And my lords, we have that. I'm afraid it's not in the electronic bundle, but we do have it in tab 3 of the respondents. Oh, my lords, we have actually got the full copy of the 1976 Constitution, if you prefer.
That was handed round.
Oh, that's been handed round already.
Yeah.
Sorry. It's section 74. The executive powers. I submit that is the source of the powers, as simple as that.
Sorry, which bit of there?
Section 74(1) and 2. The executive authority of Trinidad and Tobago shall be vested in the President.
Subject to the Constitution.
Subject to the Constitution. Well, my lords, the question is, of course, my lord, the question is, what is the effect of section 142? But if one asks, if one says that the section 142 does not apply to an invalid resignation, then we say the source of the President's power to consider the question is in section 74. This power, in my submission, gives him the power, the same power, as the prerogative power of the Crown, which was its ultimate source, subject, of course, to all the other provisions in the Constitution. But if there's no provision in the Constitution which ousts the power for which I allege, and that's my submission, then the source of the power is in section 74. Now, my lords, the heart of my submission is this. Neither the 61, nor the 62, nor the 76 Constitution ousted the President's power to consider a request to withdraw before notice had expired, or indeed afterwards. He has always had that power, and he still has it. That's the heart of my submission. My lords, can I just also, before I go to that point, I jump a little back for the moment. The Court of Appeal also found that this was a very important point, and I can just give you the references. Mr. Justice of Appeal Mendonça at page 284, para 39, and in particular, Mr. Justice of Appeal Jamadar at page 300 at para 36, and perhaps I can just take you to the latter for the moment. My lords,
Are we leaving section 74 now?
yes. Well, I was just explaining that's what the Court of Appeal would talk when the question
Say
is
that.
asked.
I mean, as far as I know, section 74 hasn't been mentioned at all in this case until you mentioned it a moment ago.
My lords, I think it's fair to say I didn't mention it in my case because we said that the President we certainly said the President has inherited all the common law powers. But, my lords, I submit that there's no doubt about it. That
We can see what section 74 says, but it's slightly surprising that in the months that this case has been going on at all levels, it hasn't occurred to anyone that that was the relevant source of power.
Well, my lords, it may just be a case of overlooking the obvious. I'm afraid that does happen sometimes. But, my lords, there's...
All right, well, I hear what you say. Anyway, where do you want us to go now?
I'll come later, if I may, to the Constitution, but just to the public interest considerations, page 300, paragraph 36. And if I can just ask you to read that paragraph to yourselves, my lords. And 37.
Yes.
And the concern of the court, in my submission entirely justified, is the President appears to have made an important error of law as to his powers. It's therefore very important, we may have done, it's therefore very important that this matter is subject to a full review, against, no doubt, all the facts and with, no doubt, further submissions and more time for them. But I do submit this is a self-standing reason for dismissing the appeal. The public interest considerations can properly form a ground for granting leave, and that, my lords, is clear from the case of Gentle, which I think my Lord Sales was involved in, which is at page 1166, tab 16. My lords, the issue in this case was whether effectively there should be an inquiry set up into the deaths of various soldiers. The important paragraph is at paragraph 22. Essentially, the Court of Appeal took the point that it was unlikely to be arguable, but nonetheless the point was of such importance that leave should be given. And 22, these are questions of some general importance, and it is, as stated earlier, for that reason we've reached the conclusion we should grant permission to appeal. Not on the basis that we've concluded the application for judicial review has a real prospect of success within 52.3, but on the basis that because of the importance of the issues and the uncertainty of the present position, there is a compelling reason why an appeal should be heard. We stress that, although we've decided to grant permission, we see formidable hurdles in the way of the applicants, don't wish to encourage them to think they'll succeed. Then 23, The question then arises whether, instead of giving permission to appeal, we should give permission to apply for judicial review ourselves. And if so, whether this court should consider the application under CPR 5215. We have concluded that we should grant permission to apply for judicial review, essentially for the reasons set out above. We've also concluded it appropriate for this court to hear the application. Mr. Singh submitted we should take that course, whereas Mr. Sales submitted we should not, and so forth. But, my lords, I do submit here the Court of Appeal has turned its mind to the question of the public importance of this appeal, and they are right in my submission to say it is of public importance. And that, in my submission, is a further reason why it would be wrong to allow this appeal. My lords, that now brings me to what you might call the meat of my arguments, and that is the arguments based upon the prerogative. That is to say, the power which I pray and aid is derived from the prerogative, and that has not been cut down by Section 142, or indeed by the Interpretation Acts. My lords, can I make a number of general points, many of which will be very familiar?
Are we talking about a prerogative power or about Section 74?
We're talking about the prerogative power which is now in Section 74.
All right, well, I'll try to get my head around that. Okay.
No, well, my lords, I submit the whole intention of Section 74 is to vest in the President all those powers, residual powers, which previously would have been in the Crown. Right,
we'll proceed on that basis.
Yeah, I'll take you to the Act, if I may, the Act which introduces the Constitution, which is referred to in our case. So, but, my lords, my fundamental submission is you start by looking at what the prerogative was, and then you ask, has the prerogative been put down, in particular by Section 142 of the Constitution, and its predecessors, or its predecessors.
And what is the prerogative power which you're saying hasn't been cut down and which helps you in this case?
Well, my lords, it's the one I mentioned at the beginning, but just for the... it's the prerogative power which has not been cut down on any footing in my submission is to agree that an office holder, with an office holder, that he can withdraw his resignation before expiry of the notice. Mm-hmm. That power has not been taken away by Section 142. And likewise the correlative power to agree after expiry of the notice that the office holder can withdraw resignation when grounds are made out for supposing that it's been procured by duress or indeed made under misapprehension.
Well, it's the second one we're interested in.
It is, but I say it's a corollary of the first, and I say the two coexist. And my point is, it is arguable that those powers are still vested.
And where's this in your case?
Oh, well, I think in our case, certainly somewhere, I think we do say, because I can't find my case at the moment. I think the way we put it is we give a number of examples at page 691. Paragraph 61. Indeed, 60 and 61, 62, 63.
Yeah, I mean, these are examples, but I'm trying to find it where you formulate your case as to where this power comes from and what it's...
Oh, well, my lords, I think 64, we're now here talking about the predecessor.
64, yeah.
64, and then 64, 2 and 3.
But it's only 2 where you talk about the Governor-General's prerogative power to treat a resignation as withdrawn even after it's been accepted.
Yes.
Where do you give the source of that prerogative power?
Well, my lords, I think actually there's quite a long historical discussion as to where it all started. It starts at paragraph 35 and 685, where we say that powers of appointment were vested in the Crown up until the 1962 Constitution, and then we explain what happens in the 1962 Constitution. My lords, we put in a note to say, in fact, it's really the 1961 Constitution, but that's immaterial for present purposes. And my lords, we trace through the position into the 1976 Constitution in paragraph 48. Thereafter, the Crown's prerogative powers through the Governor-General continued until Trinidad became a republic. And then we refer in paragraph 48 to the Constitution Act to which the Constitution was scheduled, which provides for the Governor-General's powers. And
Yes, no, I understand all that, but
Yes.
We've been shown authorities that
Yes.
before, apart from statute, a resignation wasn't effective until it was received
Yes,
and accepted.
yes,
And then we've seen that that's been sort of cut down to some extent by the Australian authorities.
yes.
What I'm looking for as an authority is what the position is after the resignation has become effective, because it has been accepted.
Well, my lords, I have no authority on that point, but what I certainly will be taking you to is an authority to the effect that a resignation can, with the consent of the Crown, be withdrawn before expiry of the notice.
Well, I mean, that's not very surprising.
Well, my
It
lords,
doesn't get you where you want to.
well, my lords, it does in my submission. In my submission, the reason being, this is part of the Crown's powers.
Well, let's look at that authority.
But can I just say what the Crown's powers are, and then I will go specifically to that authority. My lords, I'd summarise the Crown's powers in this way. First, the Crown has a prerogative power, always had a prerogative power, a discretionary power, to be exercised, quote, for the public good, where the law has made no provision. My lords, that is in the Laker case, which is at E1323 in the first paragraph. And my lords, it may be helpful, because I'm going to go to a number of propositions, which are all cited, in fact, or practically all cited, in my Lord Carnworth's judgment in the Shrewsbury and Atcham case about 10 years ago, where there's a discussion about what exactly are the prerogative powers.
Yes.
And my lords, can I just take you to that? Because I do submit it is helpful to my case to understand why we say the power is a power for the public good, and it's a broad-ranging power. And therefore one shouldn't just treat it, so to speak, as a narrow power, which can be cut down by the sort of provision we're looking at.
So where do you want to go? You want to go to my judgment in the...
Yes. It's at E1495.
Which volume of your
The volume 2, I think, my lord.
Remind me what the name of this case is? We plunged
It's Shrewsbury and Atcham, the Congleton Borough Council. I think the plan was to merge various councils together,
Yes.
and Shrewsbury and Atcham Borough Council objected to that. That was the factual background. But the discussion turned to the prerogative powers and how they were to be, what they were. And at paragraph 47, in the judgment of my Lord Carnworth, he talks about a case called Northumbria Police Authority. He then goes on to refer in subparagraph 1 to the opinion of Lord Parmore in Ayers-Caesar's case, which I don't want to take to for the moment. The important point is subparagraph 2. Lord Denning in Laker, the prerogative is a discretionary power exercisable by the executive government of the public.
Perhaps we should just see where we're going. On paragraph 44, this
Yes.
passage starts. And I
Yes.
say the existence of a residual category of ministerial power not dependent on either statute or prerogative is a matter of continuing academic controversy,
Yes, yes.
so-called RAM doctrine.
Yes.
And that's what it was about, was whether there was a
Yes.
third source power, and it certainly wasn't agreed between us all in that case, and it certainly hasn't ceased to be less controversial in the years that have passed since.
But my Lord, it may not matter for the purpose of this case, but my Lord, I'm grateful for you taking me to that.
Right?
That was the context in
Yes.
which you're considering the question of what is the prerogative
Yes.
power. But it's subparagraph 2, which I submit is important. The prerogative power is discretionary, exercisable for the public good in certain spheres of governmental activity for which the law has made no provision, such as war prerogative or treaty prerogative. The law does not interfere with the proper exercise of the discretion by the executive in those situations, but it sets the limits by defining the bounds of activity. That's a fundamental principle of our Constitution. And then Lord Denning referred to Blackstone's definition of the prerogative, following John Locke, the discretionary power of acting for the public good, where the positive laws are silent. And, my lords, I submit that it's important, because sometimes the prerogative is sort of seen as a thing which is basically a rather brutal power, and it's a good thing you cut it down as much as possible. But that's not the case. There are what you might call humane aspects to it, to be exercised for the public good. The next point I wanted to make is, again, in this same case, my lords, namely that the power extends to anything that could be done by a natural person. And I think, my lord, that is what you have already pointed out, I think, at paragraph 44, which you mentioned a moment ago,
Yeah.
and is again reiterated in paragraph 48. Now, my lord, you can see why I emphasise this. A natural person, let's say he's an employer, could certainly say, both before and after a resignation has run out, time has run out, he can say, well, I accept you were pressurised into this, and I'm going to treat your resignation as not a resignation in the first place, with all the advantages, for instance, that you have continuous employment. There's no problem with your pension rights and so on and so forth. So I submit the Crown had that power by virtue of its normal powers, as what you might call a normal human being has. Now, my lords, the next question is, how can the power be cut down? I'll come to the constitutions themselves in a moment. How can the power be cut down? And, my lords, the general rule, traditional rule was that express words are needed to cut the power down. My lords, we've quoted in our supplemental note, I think, a case of Charles Cushing. Can I just take you to that? Because it's subject, of course, to the JCPC principle, but subject to that, I submit this is the proper approach. How are powers cut down?
And the JCPC principle is very important here. I mean, that's more statutory provision occupying the field. It's not based on express words.
No, exactly. In my submission, that is the... But in a sense, one can... For the moment, I'm quite happy to accept the real point is the JCPC principle. But the importance of the reason I say this is important is that the JCPC principle applies only where the entire field or the whole ground is occupied by the statutory power. And in my submission, it's important to understand that principle in the light of the other principle, namely, express words are needed to cut down. And in a sense, they're two sides of the same thing. But there are some cases where you might say, well, we're not in the JCPC territory at all, but let's say you had a statute which said every public body must do X. Does that apply to the Crown or not? The general, original common law principle of construction would be it doesn't, because the Crown has to be mentioned as being covered. And I just wanted to take you to that principle. It's in the Charles Cushing case, which is in the respondent's supplemental, I think it's called note. It's called Respondent Supplemental Note. And it's at tab 4. And, my lords, this was the issue in this case was whether a provision in a Canadian piece of legislation which said that an appeal was final.
Do you not have an electronic page now?
Oh, my lords, if it's...
This is the one, I think, where we're 4 pages out, isn't it?
Yes. My trouble is I'm not quite sure I've got any indication on my...
Okay.
Well, it's not... No.
No, I can find it.
The question was whether a provision in some Canadian legislation saying that an appeal to the local court of appeal was final necessarily excluded a right of appeal or right to seek special leave to appeal to the Privy Council. And the Privy Council held it didn't. And the important passage begins at page 417. And you can pick it up at the foot of the page, 416. The question of the power of the Queen to admit the appeal as an act of grace, i.e. by special leave rather than as of right, gives rise to different considerations. It is in their lordships' view unnecessary to consider what powers may be possessed by the Parliament of Canada to interfere with the royal prerogative, since the Insolvency Act doesn't purport to touch on it, and they think upon general principle that the rights of the Crown can only be taken away by express words, that the power of the Queen to allow this appeal is not affected. And then over the page 418, final paragraph, there is a reference to a case called Tobago and Laudry, and then at page 419, which essentially talks about a similar problem, but 419, second paragraph, is a quotation from Tobago and other v. Laudry. Their lordships wish to state distinctly that they do not desire to imply any doubt whatever as to the general principle that the prerogative of the Crown cannot be taken away except by express words, and they would be prepared to hold, as often as has been held, that in any case where the prerogative of the Crown has existed, precise words must be shown to take away that prerogative. Now, my lords, I submit that is important, because it will be my submission that nothing in the 61 or 62 constitutions expressly takes away the Crown's prerogative that I've been talking about. I'll come to the 1976 constitution a bit later. My lords, the other aspect of the...
yes. I'm sure you will come to it, but section 1422 of the 76 constitution does use express language to say when a resignation takes effect.
Well, it doesn't say it expressly binds the Crown.
But it's obvious that it does.
Well, my lords, I'll be coming to that. But there is a separate point on section 142, but that's just the general principle. My lords, the other question, the other part of the rule, is that the whole ground must be covered. In other words, the statute must cover the whole ground of the prerogative. If it doesn't cover the whole ground, then that which hasn't been covered still remains in place. And my lords, one gets that in particular from de Keyser in Lord Dunedin's speech in the second paragraph, at page 969 of the electronic bundle. It's about halfway down the page. Nonetheless, it is equally certain that if the whole ground of something which could be done by the prerogative is covered by the statute, it is the statute that rules. And to similar effect, page 982, at the end of the page, in the judgment or speech of Lord Atkinson.
Sorry, 982.
982.
Thank you.
Last 5 lines. I should prefer to say that when such a statute expressing the will and intention of the King and 3 states of the realm is passed, it abridges the royal prerogative while it is in force to this extent, that the Crown can only do the particular thing under and in accordance with the statutory provisions, and that its prerogative power to do that thing is in abeyance. My lords, can I just, while I'm reading that passage, emphasise there's another point there, namely, that when statute covers the same ground as the royal prerogative, it doesn't destroy the royal prerogative, it just puts it into abeyance. So if, for instance, let's say the 1961 Constitution cut down the prerogative, it doesn't follow that it couldn't come back in the 1962 Constitution and so on. And Lord Moulton, my lords, at 996, and 997, 996, he points out that the wording of the relevant regulations was very wide. (997), I think, my lords, forgive me, I've given you a bad reference. It's 996, yes. At 996, the foot of the page, he starts his discussion on this point, pointing out that the relevant Defence Act was, gave the widest possible powers, and then in 997, he notes that these powers were wider than anyone ever thought the Crown had had. But again, in my submission, the point is that one's looking at a statute which unquestionably covers in all the particulars the relevant powers which the common law had. My lords, in the second paragraph on page 997, there is a reference again to the same point about the prerogative is only put in abeyance by a statute, it's not destroyed. So, my lords, that's what I say. There has to be some, you really have to be able to say the whole field has been covered, and that was the intention of the Constitution in this case, to cover the whole field. My lords, finally, can I just mention one other similar point on this, is that the rule in my submission about abrogation of the prerogative powers or discretionary powers should not be so readily applied when one is talking about the benefits which it can confer on individuals. My lords, for that I go back to the Shrewsbury case, which is at page 1499 in the second bundle of authorities, paragraph 57. And in this, my Lord Carnworth, I submit, rightly points out that many of the authorities about the prerogative and how they're cut down tend to be in quite different contexts from the one we're considering in this case. In my view, that simple analysis ignores the context in which the courts enunciated these principles. The inconsistency principle was developed by the courts in response to attempts by the executive to override statutory controls in a way which materially affected private or public rights. Compensation for expropriation of property, to Caesar, compensation for criminal injuries, a police authority's right to determine policing follow. It doesn't follow the same principle can be applied so as to categorise a course of action as illegal in the abstract regardless of its practical consequences. Now, my lords, I accept that your lordship is not there saying exactly the point that I want to eventually extract, but I submit it does help, because what is being said there is that this point about prerogative powers, you might say, well, I'm going to apply a pretty tough interpretation when it comes to things like war damage, compensation, and things like that. But it's a rather different question if what you're doing is interpreting a statute as taking away a prerogative power, which is for the mutual benefit of the Crown and of the individual. And I submit that that should make one much slower to what you might call apply the de Caesar principle. My lords, I've said what I submit the proper position is on prerogative powers. Can I just draw your attention to one authority, which I said I would a moment ago? And that's the case of Riordan, which I'm afraid we dug up last night, but we should have copies of available for the board. It's a short authority, and it's a judgment of Mr. Justice Diplock, as he then was, and it was a case in which an officer, or civil servant, had handed in his notice of resignation with notice, period given. He then wanted to withdraw it.
Yes.
And the only point I want to get out of it is that there was no right as such to withdraw it, but there was a power in the,
yes,
you might think fairly obvious, but I just wanted to make the point, but there was a power in the Crown to say, well, I'll accept the withdrawal.
Yeah.
And it's on page 1054 that one goes. At the third paragraph down, the plaintiff handed to the stall superintendent at 4 p.m., 13th of April, a written notice of termination of his employment addressed to the commanding officer, the head of the establishment at which the plaintiff is employed. Gave no date of termination but referred expressly to Regulation 438, which specifies 1 week's notice. It wasn't signed. I think this was a sufficient notice given by the plaintiff terminating his employment 1 week from the date on which it was given. Once given, it could not be withdrawn, save by the mutual consent of the plaintiff and the Crown through its appropriate officer, and so on. Now, my lords, it's maybe stating the obvious, but I submit that is because that is part of the Crown's, whether you call them common law powers or prerogative powers, doesn't really matter. It's got a power to do that, and that's why I say it's got a... Sorry,
But it's just the Crown's power as the relevant employer, isn't it?
Well,
it
is.
You really have to get into airy-fairy arguments about prerogative to explain why an employer who receives a notice of termination can agree with the employee to bin it.
Well, my lords...
I'm not saying that therefore your argument is wrong. I'm just wondering whether it's all very overblown.
Well, no doubt. In that case, I apologise.
We've got the point.
My lords, I think you have the basic point, as what I say, the power of the Crown.
I mean, the interesting thing is that he couldn't withdraw it unilaterally. Not quite sure why not, but anyway.
Now, exactly. Now, can I say what the purpose of Section 142 was? And I do submit one needs to look at the original legislation which provided...
But why? I mean, we've got this statute, modern statute, which deals with the problem. Do we really
it all goes... Well, my lords, if I may briefly, it goes back to what's in the 1961 Constitution. That's the first time it appears. And the reason, and you can see why it's appearing, the reason for the provision is because the 1961 Constitution provides for the first time for the possibility of there being a divide between the employer and the appointer. And it's against that background, I submit, that the provision, that's the reason for the insertion of the provision, and it's against that background that one has to understand what it...
It allows the first time
there was a division between the employer and the appointer.
Right.
And the 1961 Constitution provided in terms that, although in the Constitution itself, the governor was always going to be both the appointer and the employer, it provided in terms in Section 72 for the governor to be able to delegate that power of appointment. And that, in my submission, is why you find what is in Section 90, subsection 5, in an interpretation provision, which provides that you must give your notice of resignation to the appointor, not to the employer. And that, in my submission, is the reason for the insertion of the provision. In other words, it's not some sort of desire to cut down the rights of the Crown in relation to in relation to acceding to requests to withdraw a resignation. The purpose is quite separate. It's directing the employee or the office holder where he should be sending his resignation. And secondly, and correlatively, it's also saying from when the resignation is to take effect, because that, in my submission, can be important in relation to employment rights. But what it is not seeking to do is to provide that the Crown has lost its rights before expiry of the notice to say, to accede to a request to withdraw resignation, or indeed to agree otherwise, or indeed afterwards. It has no impact at all on the Crown's rights, in other words, or indeed the employee's rights, the office holder's rights, before and after notice to say, let's treat this resignation as not a non-resignation, for whatever reason that they could have done beforehand. There's nothing, in my respectful submission, in Section 142, which covers the ground. My lords, can I just take you to Section 90, subsection 5, so you can see how it first appeared? And it's in the supplemental authorities. Sorry, respondents, sorry, I get muddled up with the titles. Respondents supplemental note at tab 2. And this is the 1961 Constitution. Now, this Constitution sets up a number of offices. We have a list of all the offices which it unquestionably established. A long list. But in particular, can I just ask you to note, for present purposes, it's page 53 of the electronic bundle, I'm told. Section 53. Section 90, subsection 5, you can see the first incarnate... Sorry, I gave you a bad reference.
Section 90, subsection 5.
Section 90, subsection 5, and it's in an
Yeah.
interpretation provision.
This is one we looked at before.
Yes. Yes. I'm not. It's what appears to be the original ancestor. And you'll see how it's put in here. Save as otherwise provided in Part 2 of the Constitution. My Lords, just for your note, that is concerning the legislature, sections 14 to 45. Any person who is appointed to or to act in any office established by this Constitution may resign from that office by writing under his hand, addressed to the person by whom he was appointed. And the resignation of any person from any such office, including any seat in a chamber of the legislature, which would seem to refer back to Part 2, by writing under his hand, addressed in accordance with the Constitution to any other person, shall take effect when the writing signifying the resignation is received by that other person. Now, my Lords, the reason, one can see what's going on in this version of the Constitution, why this section's been put here. Part 2 of the Constitution concerns the legislature, and in Part 2 there are specific provisions as to how resignations are to be made. It concerns, for instance, how the Speaker is to hand in a resignation, or how a member of the House of Representatives is to do so. There's specific powers, as it were, or provisions to deal with resignation. In the other parts of the Constitution, there are not. So, for instance, if
why are we concerned with this?
Well,
you know, what this tells us that under that provision, the notice takes effect when it's received.
But, my Lords,
that would be of interest were it not for the fact that we have Section 142, which is specific to this case and says the same thing. So,
exactly.
Where do we get...
Well, but my Lords, what I'm trying to establish is that the reason for this...
We're not concerned with the reason, we're concerned with what it says.
But my Lords, in a constitution, of course, one does have to look to the background and work out... It's right, my Lord, the Constitution, we don't simply treat it like a statute. You look at the broader background and ask, what was the intention? And the broader background, in my submission to this, the broad background was there was a power in the Crown, as I've mentioned before. The Crown always had these powers. The question then is, was it the intention of this provision, which says nothing about the power to accept the request before notice? It obviously doesn't affect that. Now, it's very important, because if one looks at just saying on subsection 5, it can't mean literally what it says. This appears to be saying that you can't give notice of a resignation. It appears to be saying the moment you hand in, let's say you give 4 weeks' notice. It appears to be saying, actually, your resignation takes effect on the moment you hand the letter in. That can't be right.
Why not? Why can't it be, as it were, in escrow?
Well, my Lord, my lady, that might be the point. But I mean, my point is this. It is obviously envisaging what I submit is the normal provision that notice will be given. Some notice will be given. In other words, it's not saying, come what may, you will be treated as having resigned from the very moment you literally handed in the letter. It is allowing for the possibility that once, let's say I hand in the letter.
I mean, if that's a good point,
yes.
It is,
yes.
Why do we need to look at the 1961 order when it would be an equally good point if it were good for Section 142?
Well, my Lords, it
142 is open to the same point as to how does it deal with a resignation which is not immediate. But we're not concerned with that in this case, so we don't need to worry about it. But why do we get any benefit from looking in the 1961 order to...
My Lords, I've given my answer. I've given my answer, but if you want the point about construction, what I say is this is proceeding... All these provisions, including Section 142, are proceeding on the premise that a resignation will, in the usual way, have a provision for notice in it.
Why do we need to go along this almost a rabbit warren of analysis of what might have happened if it had been a resignation on notice, and what powers there might have been if it had been a resignation on notice, in order to answer the question whether the executive or the president has a power to consider an allegation that an immediate notice of resignation was void. It's a quite different situation. Well, I'm just not sure why I'm not in any way suggesting that that my question is intended to suggest that they don't have that power.
Yeah, yeah.
It's simply that why do we have to go round the houses? The Court of Appeal approached this by analogy with the Chung case,
Yes.
by saying, well, it's if the executive is acting on the basis of a document of resignation, and then the person who's adversely affected by having resigned writes in and says, well, actually it was void, why hasn't the government got power to address that allegation and decide whether it agrees with it?
Well, my lords,
That's the simple approach of the Court of Appeal. Why do we have to be so complicated?
Well, my lords, I adopt that approach, and I suppose what it comes down to is this. I say nothing in section 142 precludes the President from doing so. It's as simple as that. All section 142 does is prescribe what is to happen in certain events. It doesn't prescribe what is to happen if, let's say, after the event, the office holder comes along and says that was procured by duress. And my lords, I apologise for, as it were, going down the rabbit warren, but if I can come back out, I say, if I can, lordship's no doubt instigation, but I submit it's as simple as that.
Good. On that note.
But there is and certainly, my lords, the really important point, there is there's a reasonable argument for saying so.
And that's what the Court of Appeal thought.
Yes.
And I don't know that they would have been much assisted by chasing you down the rabbit warren, but that's another point.
Oh, never mind. But my lords, I say that power has never been. I mentioned the authorities earlier because I say this was always within the Crown's gift to be able to do these things, and the Crown's gift has not been affected by any of the subsequent legislation, nor by Section 142. Yeah. It covers only a specific point, Section 142. It certainly doesn't cover.
No, well, I understand that.
And that I submit, is the importance of bearing in mind the doctrine in JCPC. My lords, there's just one other point I'd like to mention, and that is the 1976 Constitution was, in fact, at the time it was passed, was subject to the Interpretation Act, as it then was, 1962, but in a slightly different form from the one we now have.
Yeah.
And that is at Bundle 1 of the authorities. I think it's Section 6.
Sorry. This is of Volume 1. Of
yes, tab 4, and it's page 760. Now, in my submission, this is the relevant Interpretation Act to look at.
Well, this, although it's the 62 Act, you say it has effect for the 1976 Act.
It was the one in force as at the date of the 1976 Act.
Okay.
And Section 7 provides no enactment passed, it's page 758, no enactment passed or made after the commencement of this Act binds or affects in any manner Her Majesty or Her Majesty's rights or prerogatives unless it is expressly stated therein that Her Majesty is bound thereby. Now, enactment, you go up to the top of the page, enactment means an act or ordinance or statutory instrument or any provision of an act or ordinance. Now, my lords, that, in my submission, binds or applies to the 1976 Constitution and also to Section 142. If I can just take you to how the powers of the prerogative powers of the Crown passed to the President under the 1976 Act, one can pick it up, I think, at tab 1, Constitution of the Republic of Trinidad and Tobago Act, 1976, which introduces the Constitution. Section 6, page 710, where under any existing law any prerogative or privilege is vested in Her Majesty in respect of Trinidad and Tobago, that prerogative or privilege shall on the appointed day vest in the state, and subject to the Constitution, any other law, the President shall have power to do all things for the exercise thereof, and so forth. Subpara 2.
Sorry, what are you saying? That somehow brings in Section 7 of the 62 Act?
No, I'm saying I'm saying the prerogative powers pass to the President by virtue of Section 6. And I also say, looking at the Constitution, the Interpretation Act, Section 142, I submit, does not bind the Crown, because it doesn't expressly bind the Crown.
I'm very worried about your going into this completely new point,
Well,
which may be of considerable constitutional significance.
Well, my lords, I think it is in our case, actually. We do specifically make this point in our case.
What, Section 6 of the...
Yes, oh yes, it's certainly in our case.
But Section 142 is about the President. It tells you that the resignation has to be given to the President. And
Yes.
when received by the President, takes effect immediately on receipt.
Well,
How can one say that? Surely that's not what Section 7 of the Interpretation Act aimed at, is it?
well, my lords,
Really, you're going down another rabbit warren.
well, my lords, I don't want to spend too long
You've had enough
on
of
that.
them.
I stand corrected, my lord.
I mean, you've got a simple, as you said a few moments ago, straightforward point, which may be right or wrong, but it's simply not assisted by this.
Yes. Well, my lords.
And we've got to be very careful about digging up odd points from a constitution here or a constitution there and trying to turn them into something which is, on which we can say something useful.
Well, my lords, can I also mention this point about the Interpretation Act? In my submission, it applies only to what is obviously a valid appointment, if you take the 1979 version.
We understand that.
And so, my lords, it doesn't provide the answer to this case. And that's what I say on the Interpretation Act. So, my lord, one eventually lands up in the same position, I suppose, as I started, but having gone round the wrong way. The power is still vested in the President. It hasn't been taken away by the Constitution, and in particular, Section 142 doesn't tell you anything about it. That's I submit the answer. My lords, can I just say this about the respondent being a necessary party? In my submission, the state, the President must be a party to this. He's an interested party, because it's to him that the resignation has to be handed. One can imagine the position if we hadn't joined him in. He might say, well, I wouldn't have minded saying something about that. I might have wanted to oppose, let's say. Or I might have wanted to concede, and that would have been a matter for the JLSC to fight it out. But supposing this had happened, we hadn't joined in the President, and the JLSC settles with us. He might say, well, on the basis that there was no valid resignation. He might say, well, that, as far as I'm concerned, that's completely untrue.
It's very...
But it's a little bit, I accept.
Quite sure you wouldn't have settled with the JLC without making sure that you'd got...
But even so, I submit that as the appointor and the person, both appointor and the person to whom the resignation had to be handed in, he did have an interest in these proceedings, and he had properly to be joined. And unless and until he said in terms, well, I accept whatever relief is granted, I'm not interested, then, my lords, that would be that.
Good. Is that it?
My lords, subject to anything else.
Is anyone? No, thank you very much, Mr. Knox. Mr. Strang, do you want to follow? Now, Mr. Stevens, we're at 1:45. I don't want you to feel under any pressure to finish by lunch, but and if you, how long do you think you need?
I might not need much longer than 1 o'clock, but I don't promise to be able to finish before 1 o'clock, my lord.
Would we be happy to go on?
Yes.
Are we happy to, I think we're happy to go, if everyone else is to go on for sort of not more than, say, a quarter of an hour, to 1:15. But if you need more than that...
My lord, I may not need beyond 1 o'clock, but I'm just not promising to finish.
Yeah, but I don't want you to feel you're being hurried.
Very well.
All right.
My lord, the first point Mr. Knox made was that the issue in this appeal affects any number of provisions in the Constitution, or appointments, I should say. In his case, he said in paragraph 2 that the appeal affects all public bodies responsible for appointing public servants. And in paragraph 24, he said, it follows from the appellant's argument that the restriction, by which he meant our contention that the President is precluded from inquiring into the circumstances of the respondent's resignation applies to all public bodies who appoint public servants, because Section 142 applies to all appointing bodies. I don't, with respect, accept that the scope of the appeal is anything like as wide as that. The appeal...
I accept that it probably does not cover public officers who are appointed by Public Service Commission, but it will cover, we had a list which I mentioned, it will cover those offices which you can see are created by the Constitution. For instance, the Director, I think the Auditor General and things like that. But it won't cover what you might call every single public officer. I accept that. Because they weren't established by the Constitution.
Frankly, I mean, it'll probably cover some others.
Well, my lord, the short point is...
General importance, undoubtedly.
I don't say it's not of application to some other offices. The answer lies in Section 142, because it applies in terms to offices established by this Constitution, including the Prime Minister and the Parliamentary Secretary, and judges are included. But there is not actually a long list of people. And to suggest that it's very wide is not entirely accurate, with respect. Sorry, my lord.
But they're quite important people.
Oh, I didn't suggest otherwise, my lord. I didn't suggest otherwise. My lord, Mr. Knox has suggested that there is a correlative power to agree that someone can withdraw a resignation after expiry of the period if, for instance, they say it was obtained by duress. And he was asked by my Lord Carnworth whether there was any authority for that at all, and it was a point that I, in fact, made. There is no authority, and he's driven to accept that. We've looked, we can't find any at all. The old common law rule, which essentially is at the heart of his case, was the one that provided that a resignation once tendered had to be accepted. And it was that that opened the door in the intervening period to something else happening. So either withdrawal or a discussion by the appointor with the person who's tendered the resignation. Well, are you sure about this? Do you really want to resign? That sort of thing. It's that and that only. There's simply no authority for the proposition which, in fact, is the one engaged in this case. My Lord, he further submitted that Section 142 does two things, or that two things are at play. First of all, he said Section 142 confers a benefit on an office holder, entitling them to resign. You can resign. But he said the second important thing is that which it doesn't do. He says it does not follow from that the office holder can't withdraw their resignation. Well, the answer is it does follow from Section 142 from its plain words, because the office holder can't do so if the resignation takes effect. Next, he suggested that you could not give a literal interpretation to Section 142, the effect of which is to deprive the office holder of the opportunity to withdraw. And his suggested right to withdraw is premised, as I understood the argument, on there being a notice period. But of course, to state the very obvious, there is absolutely no notice period when it comes to Section 142. And he might suggest that that's curious and that it ought to be construed in some way that permits of the result that there would be, were there a notice period, thereby opening the door to withdrawal during the notice period, for example. But that's only one way of looking at this. Because what Section 142 does is it entitles a judge to resign, and resign with immediate effect. Otherwise, the judge would be required to work out the notice period. So it's a significant and real benefit, and it certainly can't be construed in such a way as to allow for there to be some notional notice period or opportunity to withdraw, because that would be depriving the judge of that which prima facie he's given, the right or the power to resign with immediate effect. Mr. Knox also is at pains to rely on the legislative history, but the answer in my submission again lies in the words of section 142 of the 1976 Constitution. And it can't sensibly be suggested that these are not express words which bite directly on that which is in issue. And that's the reason, ventilated, I think, between Mr. Knox and Lord Briggs, as to whether or not really Section 7 had any, Section 6, forgive me, the Interpretation Act had any impact at all. And it simply can't where there are express words. So what one comes back to each and every time, whichever way with respect Mr. Knox approaches this, is the language of Section 142. There is also the argument about the public interest. Well, my lords, I've already submitted that if in fact the point is not arguable, then there can't possibly be any public interest served by prolonging matters, and your lordship's board should decide it. The real answer to any uncertainty is that it's open to your lordships to explain in a judgment, as you would, why the point is unarguable, and any interest there may be is served by that judgment. But he seeks to rely on the case of Gentle. Apart from the fact that Gentle was an extraordinary case, quite exceptional, with very clear public interest considerations, the paragraph in question, paragraph 22, which is at page 1167, reads as follows. These are questions of some general importance, and it is, as stated earlier, for that reason that we've reached the conclusion that we should grant permission to appeal, not on the basis that we have concluded that the application for judicial review has a real prospect of success within the meaning of the Civil Procedure Rules, Part 52.36, but on the basis that because of the importance of the issues and the uncertainty of the present position, and my lords, those words are important because if I'm right, there is no uncertainty whatsoever in the present case, quite apart from the exceptional character of what was under consideration in Gentle. And as I submitted, it's by no means unusual for courts of appeal, including this court, to perform the exercise of statutory interpretation even in the interlocutory context, always assuming that I'm right, that the point is unarguable, because I entirely accept that I have to surpass that threshold. My lord, there was one other point that Mr. Knox made in relation to, I go back now to the relevant provision. He suggested it simply didn't cut down the Crown's power to accede to a resignation. Apart from the language, which did have that effect in my submission, and also the point I made about the right which is given to the judge, there are other reasons, and the most important one is that it's very important, so far as third parties are concerned, to know what the result is of a resignation. So the example given by my Lord Sale, another judge is appointed, what is to happen?
Or person appearing in court in front of that person who purports to be the judge, are they?
My Lord, would you give me one moment, please? There's one matter I just want to check. My Lord, I think I've come to an end. I'm just going to check. My Lord, I've done it before well before 1 o'clock.
Right, thank you. Is that it?
That's it.
Thank you very much. Any more questions? No, well, thank you all very much. It's been very helpful having the arguments presented so clearly and succinctly and within much shorter than the time allotted. We will consider our position and reach a decision as soon as we can, because it's obviously important this case proceeds in some form. And thanks to not only you, but all the people who've helped with the cases. Thank you very much.